Welcome back to the Uncle Jay podcast. I'm your host, Uncle Jay. Here where we dive into sports, entertainment, and world news. I'm here with a special guest tonight, who's been here before. He's a regular on the show. Mark, what's up, brother? How you feeling tonight, my friend?
Hey Jay, how are you? Thanks so much for having me on, man. I appreciate it, man. Just glad to be here.
Yeah, no worries, man. We were on last night pretty late, and we came across this idea to have a show about something that you recently got involved in. But first, let's just touch a few things on the sports world. There was a move today with Justin Fields. I believe he was traded to the Pittsburgh Steelers. If I'm not mistaken, I think it was like a conditional fourth and a fifth or something along those lines.
Yeah, that's all it was. So it's one draft pick.
Okay.
And apparently, I haven't read into it. It just happened, and I haven't even gotten a chance to talk to my people. I'm in Chicago area, so I'm going to be talking to people about this probably tomorrow. But
that's a pretty big move.
Yeah, and so, but it was just a draft pick, and I guess based on how much he plays for the Steelers, they can they can move the draft pick up. I've never heard of that.
They can do that. So yeah, it was an exchange for the conditional 6th round pick, and probably within, the deal, the deal, if he plays a certain amount of time or he gets a certain amount of snaps, then that pick can become a better pick.
Yeah, well, that's interesting. I didn't know that was a thing, but yeah, that's part of this deal.
Oh, so, yeah, it's definitely a thing.
I mean, I don't know what you think, Jay. To me, this kind of assures that Chicago's taking a quarterback first thing in the draft.
Yeah, it looks like it.
They're kind of betting on red. I mean, you're kind of betting the house at this point. I thought that they were starting to build around Justin Fields. Quite frankly, this move surprises me a little bit. I don't study the Bears as much as the Bills. It's kind of my local friends here that are keeping me abreast of that. And you're in that environment. But this was a surprising move. Especially because they didn't get a whole lot in return.
No, I think if they would have maybe done it a little earlier on, they might have got a little bit more. But he's Russell's there in Pitt, so he's definitely going to be a backup. I don't see him beating out Russell Wilson for the starting job. So he'll definitely be able to sit for the year behind Russ. I mean, maybe Russ can teach him something. I don't know. A lot of people in football don't like Russ. Some do like him. Me personally, I have no opinion on him. He don't he don't put on a Bills jersey. I don't really care too much, but we'll see what happens. I think the Bears should have just stuck with Fields. I thought they could build a team around him in this year's draft. And, because up until this point, man, they really hadn't had any kind of real offense for him or any kind of plan for him. You know what I mean? And so now it's like the new guy coming in gets the benefits of all of the things that, Fields should have gotten. He should have got his opportunity. So hopefully things will, maybe he'll get the year behind Russ and then he'll get his opportunity. Either way, it helps the Pittsburgh Steelers out because they won't have to give him a ton of money if and when he becomes their starting quarterback. You know what I'm saying?
Yeah, for sure. And maybe it's a long-term strategic decision on the part of Tomlin. I don't know. I can't even wrap my head around this on the Steelers side. I mean, I guess I can if you're going to get a quarterback like that for basically not nothing, pretty close to it.
I mean,
you got to imagine that you're trying to just take a chance and invest in someone and get him behind Russell. And I'm with you, Jay. I don't really have an opinion on Russell Wilson. I feel like he really is a product of the coaching and the team that he's surrounded with. That's what I thought I saw with the Seahawks. And, it's just to take a quarterback that was so great a few years ago and was winning so much, and then to see what is happening now and then getting rid of him in that situation. I have a hard time understanding what all the internals of that are. That's difficult to wrap my mind around, but good for the Steelers. I mean, they've got set up at that position now. I hope it works well for them. I mean, I hope I don't I don't know if they get better than Buffalo, but I think they're going to be a tough contender, as they always have been for the Bills. And I don't know much about their defense at this point, but they seem to be looking at offense as a key part of next season, and the quarterback room. And the quarterbacks are few and far between. So I'm not surprised that they're just going to snatch them up if they see the chance. I think any team that needs someone behind the center is probably going to do that at this point, and this year in the NFL. So I don't have a lot of knowledge on that, but just that's my gut feel of why they did what they did.
Well, I've been in some of the spaces. I've been listening to some of the fans of the Steelers. They seem very happy. So we'll see how it all plays out. I mean, again, he's gonna have the opportunity to sit behind a very decent quarterback, a Super Bowl winning quarterback.
Yep.
And so we'll see what happens for him. I hope the best things happen for him. I think he's a good kid. I think he'll be a good quarterback. I don't know if he'll be great. Time will tell. But he's in the right situation. I mean, Arthur Smith, I don't know what he's going to plan on doing over there. If it's going to be, a run heavy type offense. I do believe that they're going to be either drafting a, offensive lineman or possible wide receiver. I think I see them going either or in
Yeah.
that first round. So we'll see what happens, man. Who knows? Maybe we'll
Yeah.
see them in the AFC Championship game or something. That'd be interesting.
Yeah, it would be, and they could surprise. I just don't know what it's going to look like. I think obviously Buffalo's biggest competition in the division is going to be the Jets at this point, but you still don't know how things could shake out. We haven't seen all the moves yet that Miami's going to make. They've been sucking up Buffalo players like crazy. It's driving me nuts. Just because you get that Buffalo emotional attachment to them a little bit, even though it's all business.
Absolutely.
And we'll see if they can make a difference from last year where they just didn't have all the pieces in place. And of course, injuries were a problem for them as they were for us, but we found a way to do it, especially on the defensive side. So I don't know. I think it's fun to watch, and I think it's interesting how the chess pieces move around at this time of year.
Yeah, and that's a great segue into tonight's topic, chess pieces, because what we're going to talk about tonight is basically a chess move, a chess game in the realm of someone's freedom, another person's life. And so recently you were able to be a jury on a murder trial or a attempted murder trial. And we were talking about it, and I thought, and we both thought that it would be an interesting thing to have a conversation about. Normally, we talk about sports, but there's really not much to talk about. We talked about the Justin Fields, so tonight we're going to change directions, and we're going to get into something a little bit more serious. And it's the criminal justice in the country. A lot of people don't trust in it with everything that's going on. With the prior president and his legal stuff, people don't trust in the system anymore. But you had the chance to be involved in it firsthand. Why don't you go ahead and tell us a little bit about your experience?
Yeah, I'd love to. And yeah, just to echo that a little bit, I like how you're just breaking out into different topics, Jay. We usually are talking about football. We're usually just kicking it, and it's usually just kind of a hangout and a good time. Tonight's, I think, going to be, at least for me and probably for others that listen, it's going to be a little bit more serious, and it's going to be about a societal thing rather than sports ball. So it was a very interesting experience for me, and so basically, I was on this jury, and I'll talk about it kind of in order and tell the story, and then I don't want to spend a ton of time in the story. I want to focus on the questions that come up because I'm sure some will. But I was on the most. It was a very, very unique experience being on a jury, and I'll tell you why, and then I'll get into like what that means. Just personally, and some of the things I learned from it, and some of the
Okay.
firsthand knowledge and things I learned from the justice system that I didn't know before.
Okay.
So what happened is back in January, I got a jury summons. So I live in Cook County, Illinois, which is where Chicago is located, but I'm in the suburbs. So I'm not in the city. we have a lot of traffic, and so it usually takes me probably close to an hour to get into the city, and it can be longer depending on traffic. So I'm way outside the city. I'm out past O'Hare. I have to drive towards the city like to get to O'Hare if anyone's looked at that on Google Maps. And so I've been called in for jury service. I've received a summons probably 3 times in my 15 years here. And that's probably pretty normal. I talk to my friends and they get one every few years. And every single time I've had to go downtown to the big criminal courthouse downtown. There's a courthouse out here close to where I live, but for some reason I never get summoned. I got to go all the way downtown. Each time I've been down there, I came into the big jury assembly room, but I got dismissed because they didn't need anyone. So they obviously have to call in a lot more people than they're going to need, just because there's a selection process and there's a lot of different things going on. So I expected this to be the same. I thought, well, I'll go down there and bring my computer. They have internet and such, and I can kind of keep up with work. And then probably 1:30 in the afternoon, they'll say, "Thank you for serving. We don't need any more jurors in any of the courtrooms. You're free to go. And here's your 30 or now I think now it's $35 check."
Oh, okay.
So they give you a little payment, and then it kind of covers your costs, I guess, for getting down there. Doesn't cover your costs, if your employer doesn't, pay you for that time. So
Yeah, some employers don't.
Yeah,
right?
some employers don't. So that can be a big burden for people. And so
Absolutely.
I'm fortunate that jury service is treated as a paid vacation day, so I don't have to worry about that. But yeah, many don't, and that's an issue for sure. We're not going to dive too much into that tonight, but I did want to mention it because I'm just kind of sympathetic to those that don't have as many options.
Yeah.
So I was like group 14. So they assign you random groups when you get there. And I found out when I got in the courtroom, I didn't know how this worked, but once I got in the courtroom, I found out that was a group of like 20 people. So they'll call in like groups of 20. So anyway, I waited all morning, burned up my battery on my laptop working. Then we had lunch break, and then afterwards I go back into the jury assembly room, and sure enough, my number gets called, group 14 coming in. Ended up going to a courtroom with another group. So we had about 40 people total that were called into the courtroom. And from that 40, they're going to select a jury of 12 and then some alternates. And so, and the reason I'm talking about this is I realize that maybe some people that are listening have been on a jury before and they understand that process. But if you've never done it before, I thought I'd just kind of explain how that process works. And
No, that's fine.
It's all new to me. So I'm getting a little bit bogged down in the details there. But so we ended up going in 40 people, and then we're sitting in the back of the courtroom in like the audience section, and we get called up according to whatever formula they had. And I was among the first group to get called into the courtroom. So they bring in 12 people. And you go and you sit down in the jury box. And what happens at that point is there are standard questions that the judge asks. So both sides, the prosecution and the defense, get to ask their questions. They both have the opportunity to say no.
They can either choose you. They can either say, yeah, I want him, or no, I don't want him. And I believe they get a certain amount of they get a certain amount of those where they can reject someone, you know what I mean? And then once they get to a certain amount, they can no longer reject the process. It's something like that, right?
That's exactly right, Jay.
Okay.
And I didn't get to experience any of that, by the way, and we're going to get into that. But
okay.
But yeah, like basically the prosecutor and the defense attorney are saying, yeah, we want this person, and if they both agree, then that person is locked in.
Yes.
But they have, I believe it's five excusals that they don't have to provide a reason for. Now, if there's a reason, if that person has answered a question in a certain way that shows that they're going to be biased or unfit for jury service, then the judge can agree that, yeah, they should be excused. They're not going
without them losing one of their excuses. Okay,
yeah, it's almost like, now we could talk football. It's almost like not losing your challenge or not losing your
got you. Okay, that's what's up.
So, but yeah, that's the case. And so, but we went through the standard questions from the judge, and one of the standard, and here let me say this: I never expected to be on a jury. I shouldn't have been, on a jury according to how most of these cases work. And here's why. Some of the questions that the judge asks include things like, do you have any friends or family in law enforcement? Do you have any affiliations there? And I've got to say, yes, my best friend, one of my best friends is a deputy sheriff up in Wisconsin. And
Uh-huh.
we talk about his job all the time, and he's my buddy. So, typically I would imagine that when someone says yes to that question and explains why, the defense attorney is just going to be like, we're not, we're not taking that guy. So here's
Yeah.
what happened in this case. And here's where it gets a little bit crazy to kind of,
Because there's an interesting part that normally doesn't happen in a lot of these cases. But go ahead.
yeah, no, that's exactly right. So when I went into the courtroom and started answering, and we all answered the judge's questions, there was nobody at the defense table. Weird. I'm like, I don't. That's kind of odd. Usually, everybody's in the courtroom at that time. But the judge explained that this defendant was representing himself. He explained the charges. So it was he was charged with attempted murder.
Okay.
He was alleged to have shot somebody and
Okay.
paralyzed them and injured them
Wow.
severely, but without
Mm.
killing them. And then that was the main charge. And then they also charged him with aggravated battery with a firearm, meaning,
Okay.
that's again, it's another charge where you shoot somebody and hit somebody illegally.
And you would have had to have found them guilty on both of those counts, right?
Not necessarily.
Okay.
We could have picked a count and said he's guilty on that and not guilty on the other.
Okay.
Now, logically speaking, you cannot convict someone of attempted murder with a firearm and not convict them of aggravated
Yeah,
battery.
I actually I said that wrong.
So,
I was going to say that you were going to be forced to find him guilty on each charge.
yeah,
Innocent or guilty on each charge is what I
yeah,
meant to say.
but
I
it,
worded it wrong.
but that's exactly right. No, you actually didn't say it wrong, Jay. It was each charge was independently considered. So
Okay, got you. All right.
theoretically we could have convicted him on one and not on the other. For example, if we thought that there wasn't intent to murder, we could have just convicted him on the aggravated battery with a firearm charge. And intent comes into play there, and that's another whole thing.
Okay, got you.
But there's no one at the defense table, and so wow, that's weird. And the judge quickly explains that this defendant is representing himself. He has chosen not to retain attorneys, even though they're available to him. And furthermore, he has elected not to be present during jury selection.
Mm.
So,
And hold on, before you go on,
no, jump right
isn't
in.
there something that a judge always says when someone is wanting to represent themselves? What's the saying? Man, it's on the tip of my tongue. Um, they usually don't allow. They usually don't want people representing themselves because, man, what is it? If you represent yourself, you're. I can't think of it. I'll think of it while you
Yeah,
continue your
you'll think
story.
of it, but you're right. It's a terrible idea. It's
Yeah.
the worst idea ever. And as this case played out, you could see that in real time how terrible of a decision that was. Um, I don't understand it. Maybe he distrusted attorneys or had an experience or something like that. But that's what he chose. So he chose not to be present during the jury selection, which is his right. And by the
And
way,
he could have had a code a public defender, right? He wasn't wealthy enough to where they weren't allowing him to have a attorney
correct.
if he couldn't afford one. Correct? I
Yeah,
mean,
that's a good point. So
yeah,
yes,
you're
he
supposed to have
qualified.
representation no matter what. You know
He
what I mean? So
qualified for public defense. He was afforded the
okay,
opportunity for public defense, and
he chose to represent
he
himself.
declined it against the judge's very stern advice.
I think the saying is like a person who represents themselves has a fool for an attorney or something like
Yeah,
that.
that's
It's
yeah, that's
it's
probably
something
it.
along those lines. But yeah, it's weird too. But
Yeah,
go
it's
ahead,
just not an
proceed.
avenue you want to go down. It's so technical when you get in the courtroom There's things you can say, can't do, can do, can't do, things that are effective, not effective. And this guy broke every rule that there was, and it was just a mess. And I'll talk about that in a minute. Um, but so yeah, this was where we're at. So all of a sudden, the state's attorneys, the prosecutors, get to pick whoever they want for jurors without any pushback
Pushback,
whatsoever.
absolutely.
So,
Crazy.
so of course, Mark, with the best friend that's a cop and all this other stuff, of course he gets on there. They're going to pick me. So the guy that never should have been a juror, all of a sudden was a juror because of this. Um,
Because
circum-
of this person who chose to represent himself
yeah.
instead of getting a quality attorney.
And that's what I think. I mean, it's possible they both could. It doesn't necessarily disqualify you. I would just logically think that any good defense attorney would say, no, I just don't want someone that's friends with cops. That sort of thing.
Absolutely, absolutely.
So not that they're necessarily biased or anything like that, but yeah, it's common sense. Um,
Yeah. So normally a guy like you would not ever find his way on a jury for any kind of crime that would have any affiliation with law enforcement. No defense attorney is
for
going to want that person on the jury, although the prosecution very much does. So that's
sure.
kind of like where you got caught in the pickle. You know what I mean?
Yeah, and I would not expect to ever be on a criminal trial. A civil trial, perhaps, but
Yeah.
certainly not a criminal trial, just because it's like
Mm.
there's a lot of other people that you can get that don't have any interaction with law enforcement or this, that, the other. Um, just trying to jump back to, let's see where I was, but so we did jury selection like on a Tuesday. I went down on a Tuesday and we did the selection, and then court takes forever. There's a lot of like processes that they have to go through. So it's like 4 p.m. on a Tuesday. And the judge says, well, I don't want to start the case. It's already, almost quitting time. So we'll let you go. And you guys come back tomorrow morning. We'll start the trial on Wednesday morning. So I drove home and drove back in. And I thought, you know what, man, this drive is just, it's not a lot of fun. And we could be there late and everything. So I said, I'm going to pack some clothes and I'm gonna plan to spend a night or two downtown. I'm just gonna get a last minute hotel, just find a deal that's close or something like that. So that's what I did. I spent 2 nights in Chicago. That was actually a lot of fun. I went out and did some stuff just for a short time after each night, and it was good because the drive was just not fun. It was miserable. So we get in
Yeah,
on
who doesn't want to hang out in Chicago for a couple days after,
oh,
when the day's work day is over?
that's exactly right. There's so much to do. There's places to go out and eat and drink, and that you don't
Yeah,
have in your area. So I mean, I was all right. I might as well hang out for a bit. And
absolutely. I went to the first steakhouse I found, got me a nice steak, nice
yep,
stiff drink, and relaxed. But go ahead.
that's that's exactly what I did, man. I went to a steakhouse I would have never went to. I didn't even know it existed, but it was downtown in the Loop, and it wasn't one of the famous ones that you would find if you looking for the best steakhouse in Chicago. It was more of like one of these low key local places. It was good. So
Awesome,
yeah,
awesome.
spot on, man. You got to find like the diamonds in the rough, in a situation.
Absolutely. The little hole in the wall, you know what I mean? That's got great food and strong drinks, and you have a really good time at those places.
Exactly. So we got in on Wednesday morning. They started the trial, and what happens at the beginning is that the prosecution gets to present their opening arguments first. Now this isn't evidence, and it's the judge's instructions were clear that you cannot take these arguments as evidence. You can listen to them; it's part of the process, but you're not allowed to consider them as evidence, which is really interesting because in my mind, I'm like, okay, then why do it? I work in a corporate environment. I don't waste time with stuff that doesn't help.
Yeah.
But it's just part of it's just part of how the cases roll through, and both sides have a chance to present. So
It's
that
all about the evidence. It's
yep,
not so much what's being said, it's about what the evidence says. You know what I
that-
mean? Not so much what the attorneys are saying. It's about what that evidence says. You dig? And so that's
yep.
what I get from, the law inside the courtroom. But go ahead, proceed.
No, you're absolutely right, Jay. And what the attorneys are trying to do is to do what a little bit what I'm trying to do right now that I'm not good at, by the way, is tell the story. So they're going to present the evidence, but they're going to talk about at the beginning what the evidence is going to show. And then at the end, they're going to recap that and say, this evidence showed X, Y, Z, and here's why you should find him guilty. Or on the defense side, they would say they had this many holes. It doesn't make any sense. You can't reasonably believe that. Here's why you should find him not guilty. That thing, of course.
And those are called the opening statement, the opening arguments, and the closing arguments, right?
Exactly.
In the beginning, you have the opening arguments, and then at the end, you have the closing arguments. And so, go ahead, tell us about the opening arguments process.
Yeah.
That's where we're at in the story now, right?
Yep. And
Okay.
it's gonna. I'll move a little bit faster
No,
here,
that's fine.
just
Take your
because.
time. I'm just trying
Um,
to kind of explain it a little bit more,
okay. Yeah, I
as
can
we
slow it
go.
down. I could talk about this for quite a long time. I definitely want to have some time for questions and
Basically, what I'm
everything.
doing is I'm just kind of throwing it back at you to make sure I understand you correctly.
Yeah.
And so I'm taking in what you're saying and I'm saying, all right, well, this is what I'm seeing from what you're saying. So we're at
Yeah.
opening arguments point for the prosecution.
That's
Proceed.
good. Yeah, that's exactly right. So that's how it works. That's precisely how it works. How you outlined it, and that's what I saw in the courtroom. And so opening arguments. Obviously, the state gave their statement, and they're polished attorneys. They've done this a million times. This, that, the other. The defendant now, he didn't have to come in the courtroom. Now the defendant decided that he was going to show up. So we did have the defendant in the courtroom all of a sudden on Wednesday. My first time seeing him. And so he had no attorneys. He's there by himself. He was flanked by three plainclothes sheriff's deputies
Okay.
on both
Now,
sides.
did they allow him to wear regular clothing or did they make him wear the orange jumpsuit or the gray whatever I know
Yeah.
that it's different colors in different states. Here in my state, it's orange. So
Yep.
was
Well,
he
yeah.
presented?
Yeah, absolutely. I'll address that, and it actually changed on day one. But
Okay.
so he comes in flanked by sheriff's deputies.
Okay.
There's three right around him, and then there's one just off to the side.
And that
Um,
doesn't look good.
No, it doesn't have anything to do with the trial, but you see it,
Yes, absolutely. That's what I meant
and
by
you and you yeah, and
you're
you
not
wonder.
supposed to that isn't supposed to move the needle at all. But as you said,
Exactly,
you see
exactly.
it, and seeing that is, it isn't easy to just say, okay, and I know you're gonna get to that even more as we go along because that's what this shit basically is all about.
Yes, yes,
So go ahead,
absolutely.
go ahead.
So, yeah, that's good, and that's what it is. It's like, well, you don't know why that is. You don't know anything about this person. You don't know anything about previous history, whatever. But I know from my experience with law enforcement that those cops are around him because he has done something at least somewhat violent in the courtroom in the past. Because typically, now again, it doesn't matter. I didn't take it into account. I'm just like, oh, okay, well, he's been upset about something before or exhibited some sort. Maybe he just yelled or I don't know. And I truly didn't take it into account. But yes, there and something I'll talk about later is the implicit biases that come up. But
During a trial like this with
yeah,
someone who's representing themselves, someone who's probably low income. I mean, because if he had money, he wouldn't have chose to if he's got an issue with law enforcement and the 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 law and he doesn't have his own attorney, then that means he can't afford to go out and get a really expensive one. He doesn't want the public defender because again, he doesn't trust the legal system. So, he's representing himself. And so he's got these cops standing all around him. So, right from the start, it doesn't look good for this particular person.
yeah,
On
it's
top of
just
the fact he's being charged with attempted murder and
mhm.
assault and battery with a firearm. So, go ahead.
Yeah, so it's a little bit weird, but that we're gonna proceed. We're gonna see. So that's the first indicator that told me this is not gonna be. I mean, obviously the previous day when he said he was self-represented, I knew it was not gonna be a normal trial. And
Yeah.
I kind of felt bad for him, like, just dude, you're out of your depth. Just don't do that. But people can choose what they choose, and that you can't take that into account. It doesn't have anything to do with anything. So we went through the opening statement. Of course, the state did theirs, and they start to introduce the case. He had an opportunity to do so. He didn't really say a whole lot. Just said basically, I'm not guilty of this, and I think that the state does not have a case, and I think that that will bear itself out, and I think that that'll show. And I just hope that you guys can see that. And so it was a little bit disjointed, a little bit sloppy. Obviously, he's out of his depth. He doesn't know what he's doing, but he had an opportunity to speak, and he did address the jury. Um,
Okay. Okay.
not like a complete idiot or anything by any means, but just out of his depth. Like, should
Yeah,
have.
he just pretty much said, "Hey, listen, man, I didn't do this. Their stories got holes in it, and I'm
Yeah.
hoping that you will all see that and come to the proper decision and set me free."
Yep, that's really that's a good summary. So the opening arguments conclude, and then the state calls their first witness, and the first witness was the most was the most significant witness. The state called the victim, the person who had been shot, and so
Okay.
this was a young man, about the same age as the defendant. So they're both probably in their 20s. And,
Okay.
and now I get to call them young now that I'm in their 40s, now that I'm in my 40s. And so
Yeah.
it's weird to call them young men, but they were young men. And so he came into the courtroom in a wheelchair. So he was rolled in, and they started with the testimony, just explaining that the state asked him what happened that day. And I can get into the details if you want me to.
Absolutely. I want the people to understand what actually transpired that day so they can get an understanding of what, you guys had to, how you came up with your decision, what was
Yeah. Okay. So yeah,
presented to you, you know what
that's
I
good.
mean?
Then
So like, yeah,
let's
let's get
jump
into
into it.
it.
Yeah, I was just trying not to stretch it out too far because it's a crazy story. But
It's
um,
fine.
so
Hey
good,
man, like I
good.
said, if it ends up just being me and you, then it's just me and you. I want to hear about the entire experience because I'm a taxpayer and I want to know that, the system works. You know what I'm saying?
Absolutely. So this is where we started to really hear the nuts and bolts of the case and what had supposedly happened. So the victim was from Chicago, but had moved out of Chicago. I think he had moved to California for whatever reason. He came back to Chicago to on Memorial Day weekend to hang out with his buddies. He was going to a house party, and I think to pick up his daughter, and bring her back to California or something like that. I don't know. There's some
Okay.
sort of family plan involved in that. So he testified that he went to this house party. Which is in a residential neighborhood on like the southwest side of Chicago. So, really, really populated and everything like that. It's one of the older neighborhoods of Chicago. It's also
Okay.
one where there is a relatively high amount of violence. So if you hear
Okay.
things on the news, sometimes it's in those neighborhoods. I don't think the neighborhoods themselves like always represent violence. I just think that, there's a lot to unpack there. But anyway, so he went to this house party, and he walked up to the house, and it's
Okay.
Memorial Day. It's nice weather, and there's a couple kids playing in the front yard with a water hose because it's warm enough to spray each other or whatnot.
Uh-huh.
And they're kids are being kids, and a little bit of water got on the victim. He said. And he said, "Hey kids, you need to be careful, and you need to don't splash me." And the kids were fine with that. He said, "Oh, they apologized and said, yeah, I didn't mean to splash you. Sorry." But he kept kind of pushing it, saying, "No, you really got to be careful, and don't do that again." And a couple people at the party got mad at him for that, just because he kept, apparently, I don't know all the details because we only went into what was the state felt was necessary to prove their case. But people at the party got mad and confronted him, and there was a verbal argument, not involving the defendant, by the way. It was other people at that point, which
Okay.
everyone agreed to. There was no contest there. Uh, so there was a big verbal argument, people yelling at each other, this, that, the other, and the victim testified that he just decided, I'm just going to take a walk and cool down. I'm going to come back, and I'm sure everything's fine, and people just got to relax. So he walked away and went down like an alley. And in Chicago, in those residential, those dense neighborhoods that have been there forever, there's
Yeah.
alleys all over the place. Like behind your house could be an alley for your garage and your trash cans. Between the houses, there's alleys. It's pretty tight, but it's laid out in a way that allows, you to have a single family house, but also have some place to park your car or
Yeah.
whatnot. So he walked down an alley, and then he testified that the defendant rolled up on him in his car, which is a red Pontiac, and that means something that I'll bring up later. Um,
Okay.
and the defendant got out of his car with a gun in his hand, not raised toward him, just holding it. Walked up to the victim, patted him down around the waist to see if he had a gun. Words were exchanged. Again, this was a guy that was, it was agreed by all parties that wasn't even involved in the argument in the first place. So
Okay.
who knows why, or even if that happened. But uh, so patted him down, got back in his car, and drove away. The victim started walking back to the party because that's where everyone was. He had come in on the bus. He didn't have anywhere else to go. And if it were me, I wouldn't have gone back to the party after that happened. But for whatever reason, he was going to go back. He thought everything was going to be cool. And so he's walking down like the side alley of the house and walking towards the backyard where kind of everyone's cooking and hanging out. And he testified that all of a sudden the defendant came out of nowhere holding a gun. I don't know what side he was on or anything. We saw it later what side, he was supposedly on based on the gunshot trajectory. But, and then so the defendant's holding the gun again openly in his hand. And the victim says, "Hey man, are we cool? Is everything okay? I'm not trying to start anything or whatever." And according to his testimony, the defendant did not respond, didn't say anything. So the victim then turns around. He was facing the defendant, turns around, his back is now to the defendant, and he's going to keep walking down the alley, go to the party, and just be like, "Oh, this guy's angry, let him cool off," whatnot. And at the point that he turned around, he was shot multiple times. He received shots kind of all over the place up top, nothing fatal. He's really lucky. One of the shots hit him in the elbow and broke his arm. The worst shot hit him in the lower back and caused him to be paralyzed from the waist down.
Oh.
So he just, he fell down. There's blood. Everything's crazy. And they call, obviously, the police and fire. Everyone responds. Everyone's got body cam. But, the whoever shot him was long gone, by the time they show up. So whoever shot him, even though I know it was the defendant, I'm going to say from the case perspective, let me put myself in the middle of that case. No conclusions yet. So we're just hearing everything out. So whoever shot him is long gone. And, he just waiting for people to show up and help him. So we saw body cam at that point just to show like where he was, just to show like what kind of injuries, to show like what kind of questions they asked him when the police and the fire department got to the scene, to show kind of what the scene looked like, to kind of give some space or some perspective on the space that they were in. And so they walked through all this, and this is all part of when they're questioning, or the prosecutors. This is all part of their examination of this witness who was their witness. And so he's recounting everything that happened like in real time. He's watching the body cam and he's looking, and they got to a point in that testimony where they asked him who shot him. Like, is that person here? And he looked right at the defendant and said, "You shot me. You shot me. You shot me." And by then, and some things that happened, something I didn't mention that happened throughout the trial was, the defendant didn't know what he was doing legally. And so he kept he would start talking or talk out of turn or this, that, or the other. And the judge would basically get frustrated with him and tell him to knock it off, but try to give him a little bit of leash because he's self-representing and you want to you don't want to railroad him. Right.
So he was just interrupting. He wasn't objecting. You know how they say objection, Your Honor.
No, he was objecting. He just didn't have good objections.
No basis to his objections.
Yeah, there's
gotcha.
No basis.
Okay.
So he kept trying. And so that was some pretty long and some pretty powerful testimony. And that was it was, I'm going to talk about emotions here towards the end and how heavy, the burden was of making this decision. But that was an emotional moment. It was just, there was something notable when he looked at that guy in the eye, or just looked at him and said, "No, you shot me. I know you shot me." So there's cross-examination. And so the defendant got to ask the victim questions, which was also like, oh, wow. So now the guy that is alleged to have shot this guy just gets to ask him questions and get into all that. Like, it's just mentally, you're like, this is just crazy.
And the defendant doesn't know what the hell he's doing, because he didn't have any experience in being a lawyer or knowing how to represent himself or anything. So it's just going to be a mess.
Yeah, and that's what it was. So he did have some smart questions here and there. They were peppered in, but he
Okay.
also asked a lot of things that they're not relevant to the case, or they're not allowed to be asked in that way. And obviously, they're questions that an attorney would know his way around and how to ask. But he had so many things that the state would object to, or the judge himself would object to. A judge can object. A judge can shut it down anytime he wants. He doesn't have to wait for the other side to object. He can just say, nope, that's improper. So that
Yeah.
was happening like crazy. I don't know if anyone, I don't know if you, Jay, or any of our viewers tonight ever watched any of the Daryl Brooks case in Waukesha, Wisconsin, a couple years ago. Daryl Brooks was convicted of driving his car through a Christmas parade.
I
In
remember that. Yeah.
and he killed and injured several people, including children, if memory serves. And it was just a tragedy for that area. And he self-represented. He got kicked out of the courtroom. He got sent out to like a separate room where they could mute his mic or whatnot. It was literally heading that way. This was this
Okay.
was like this was like Daryl Brooks like defense all over again, but just not quite as bad. He didn't end up kicking him out or anything like that. It was that crazy though, and you kind of can't believe what you're watching. And then in the middle of all that, you're a juror and you're supposed to be keeping all this straight. So
Yeah.
if the judge says you've got to disregard something, you're trying to figure out and keep track of everything you're supposed to disregard, and then keep track of, more importantly, what you are to regard. It
Yeah.
was just a mess. We all had notepads, and you could take notes, but it was hard to keep up with. Just pretty wild. So I'd say that's the most substantial part of the trial itself. There were other witnesses the state called, like a detective that worked on the case to see what he found, and so he testified to what he found. They called a forensic expert with the Illinois State Police, who handles the issue of proving that the bullets, that the bullets fired from, that the bullets that hit this victim, that were found in this victim's back or whatever, were the same bullets that were fired from the gun that were found on defendant. And
Got you.
so you've
Okay.
got that person talking about their experience, and there's no assumption at all, by the way, that, oh, well, they did the ballistics, they kept the chain of evidence good, it must be fine. That person comes in and from scratch gives their qualifications, their training, they explain about the science, and then they say, well, what does that science mean for this case? Well, we tested this particular bullet and we tested this gun, and we found that the characteristics that gun put on that bullet, which are unique to every gun, apparently, I'm not an expert in this field, every gun apparently puts unique characteristics on a bullet that are,
Yes.
it's kind of like a
It's
finger.
called ballistics.
Yup. So it's kind of like a fingerprint. We all have a unique fingerprint. That each gun puts a unique fingerprint on the bullet, and there's some science behind
Absolutely.
that. But you have to trust that science exists, that it's true, and that this person is qualified and not biased in their assessment of that. So all that comes into play, and the testimony is framed as such. There's no assumption that, well, we just know the science. No, we go from the beginning and we outline to the jury everything that's done, what it means, what's the training, the competencies, how has this been proven, before. All that gets fleshed out a little bit. So we had those, those testimonies as well. I'm going to jump forward. I've got some notes here written down just to kind of keep me on track. But
Okay.
I was making sure I wasn't missing anything there in scrolling through. But so we get all these witnesses, and in the middle of that, the defendant is just, making a mess and it's a little bit of a chaotic situation. And finally, the defendant gets to present his case. It's his turn. The prosecution rests. They've called all their witnesses. They've done everything they could. So that's when it really got kind of crazy, just because the guy didn't know what he was doing. And the judge just was striking down one thing after the other. He brought up things that were not relevant to the case.
Well, what are some? Give us some of what he was trying to do. Well, I understand that he
Yeah,
wasn't prepared and he didn't know what he was doing. But let's hear some of the things that he was saying. If you can, if you wouldn't mind sharing some of those things, so
yeah,
that we can see what
absolutely.
what you've had to listen to and endure.
And no, absolutely. Those are good examples to bring out. I agree. One one I'm gonna say one little silly thing that came up, and then I'm gonna talk
Okay.
more about what was persistent throughout the trial. Um, when he cross-examined one witness, he started out with, "Sir, Mr. So and so, have you read my books?"
Mm,
And the judge is like, "What are you talking about? None of your books have anything to do with these. If you've written books, those don't have anything to do." So that was just, struck down, and we were all like, "Oh, okay. I guess he's an author." Um, what was more pertinent, I guess, to the case was, all right. So here's one thing I totally forgot to mention this, despite my notes. This defendant insisted from the beginning that he had not received any of the discovery. And discovery is just what
the
that means.
evidence.
If you're not familiar, both
Yeah.
sides must give to the other side
Hmm.
everything they're going to present in trial.
Yep.
There's no surprises in a trial. Whatever the prosecution is going to use against the defendant, they have to turn over to the defendant and the defendant's attorney.
It's called
Whatever,
discovery. Yep. 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 Yep.
and conversely, anything that the defendant is going to use to defend him or herself must be turned over to the prosecution in advance. And there's this long process before the trial and that's usually the reason why it takes so long to get to trial is because of the detail with discovery. So
Absolutely.
from the beginning and throughout the trial, this defendant insisted that he had not received any of the discovery until 5 days before.
Mm.
And this was it was absolutely false. I don't have to be there and see the paperwork move to know it's false. I know how the court works. This incensed the judge, and the judge just struck him down. He sent us out of the room a couple of times so that he could talk privately with the parties, and I'm sure it was to say, we don't know what was said, but I'm sure it was to say, if you pull this again, then you're not going to be able to talk anymore. But he kept insisting, "I've only got it 5 days before," and everything. And every single time the judge said, "That is a lie. You had plenty of opportunity. You insisted on a fast trial. We gave you the opportunity for discovery. You did not avail yourself of the opportunity. You had every opportunity to do whatever you needed to do to prepare for trial, whether or not you had representation. Do not stand here or sit here in my courtroom and say in front of the jury that this lie that you got it just 5 days before. Because if you're going to do that in front of the jury, then I will reprimand you in front of the jury."
Mm.
And that's like how that went. And I raised my voice because I reflected exactly kind of what the judge did there.
No, thank
So
you
we
for
had
that.
that. We had that like the whole time. And so he eventually at the end this was Thursday. So Wednesday night the trial was not over, so we all went home Wednesday night, or I went to my hotel that I randomly found and then got a stay. And then we came back Thursday to finish the trial. And Thursday the prosecution rested, and it was his opportunity to present his defense, to call witnesses, to do whatever he could. And obviously, he wasn't prepared. He didn't call any witnesses. He kind of just rambled and talked and tried to like poke holes in what was done already. It eventually turned out that he was so off topic and refused to come back to proper uh, procedure that the judge rested him. and
Okay.
and that could be controversial, I know, and hard to understand. It sounds bad.
Yeah.
Totally appropriate. It's legal process, and the judge gave him a long leash with everything, but he wasn't presenting a defense. He was saying all these things that aren't allowed to be presented. So the judge forced the rest, and we got the case, and it was like a Thursday afternoon, just after lunch. So what I was talking about a little bit earlier is just in how it affected me was the weight of that responsibility. You're charged with listening to this evidence and listening to everything, and you're responsible for what happens to this defendant and whether or not they spend. Now, we don't take sentencing into consideration. The judge specifically said there was a bunch of other instructions. Our only job is to weigh the evidence and decide if he's guilty or not guilty based on the evidence and the evidence alone, right? But still, in the back of your mind, you know that a guilty verdict means you're sending this guy away, and
Yeah.
he's going to pay the price.
Yeah.
So one of the things that's heavy in your mind, and I know it was heavy with all the jurors, and I'll talk a little bit about that, but was that it was such an impactful decision that we had to make as just as random people from the community.
Citizens of this country.
Right. So that weight, I mean, I was just like, and I'm sure everyone shared it with me. There was that nervous, that sinking feeling when both sides rested, and you know it's time. Now,
Yeah.
now we talk about it. Another thing is that the jury, we don't really talk at all until we get the case. Well, number one, we're not allowed to talk about the case to each other at all until it concludes. So we might be all in the room together, all 12 of us sitting around this big table and eating snacks or whatever, but it's awkward. You don't know each other. It's a serious situation. Nobody really talks except for a little bit of small talk here and there. And then as soon as we get the case, all of us 12 strangers now have to get together and share all of our views and try to work through this very, very serious matter and come to a unanimous decision in the end. So that's a moment that was just, I would just say, remarkable and salient, maybe. And it was a time when you felt the weight of that decision.
Man,
Um,
when you say it like that, I think back to the movie 12 Angry Jurors.
yeah,
Something
12
along
Angry
those.
Men or something like
Yeah,
that. I
something
didn't
like
see
that.
it. But,
12 Angry. It's an old black and white joint, and
hmm.
it's an amazing movie. And so yeah, that's the first thing that popped in my head when you're saying that. But go ahead. I didn't mean to interrupt you.
No, no, not at all. I mean, that's that's interesting. I'm not surprised that movies would be made about it, but it was just heavy, man. That's all I can say. I mean, it was not easy. It was exhausting psychologically, emotionally. It was just a crazy case to begin with all these. Usually it'd be easier, right? The person would have an attorney, attorneys would go back and forth, they do the evidence, it'd be a little bit more simple. But now you're in the situation that where you're witnessing all of this on top of what has to happen, in the courtroom. So, we got the case, and we did an initial poll. We elected a four person, and we did the initial poll, and 8 out of 12 right away said, I could walk back into the courtroom now and find him guilty. I do see that it has been proven beyond a reasonable doubt. Three of us, including myself, said, I'm not ready to definitely I'm not ready to just walk back out. I need time. I need to sort things through. It was a complicated case. I need to look at my notes. I need to talk to you guys. And then one was a definite, like, no, they haven't done their job. They've not proven it.
Okay.
One thing I forgot to mention. So there's two pieces. There's basically, this case rests on two pieces of real evidence. One is the victim's testimony. So we have to evaluate the credibility of the victim's testimony. The other thing is that they found, and I didn't talk about this, and I missed it like at that time, but I'll bring it up now. They
Okay.
found the gun on the defendant that was proven to be used in the shooting through ballistics. They found it on him when they arrested him 2 months later for something else.
Okay.
So that, I think, really was the, like, obviously defendant was there. He was the only one that had a gun. He obviously had a beef with this guy because he went after him or whatever, which that's all testimony. So it's not, for certain that happened. But
Yeah.
no one argued against it. And like, who else could have shot him? Yet the victim had turned around and didn't see the shooting with his own eyes.
Got you.
The gun was found on him, but 2 months later. How many could that gun have been passed around to different people within those 2 months? Does the fact that the gun
Yeah.
was found on him mean that he shot the person? That's what we were wrestling with, and that's what happened in the deliberations, and it was difficult. So our task was to decide based on the totality of the evidence which way it leaned, and so with time, myself and then the two others, they took a little bit longer. I was already leaning towards guilty, but I needed to be certain. I could not, I could not just write this off really fast. I need to spend some time and just be careful and know that we're making the right decision. I would rather let 100 guilty men go free than to imprison one innocent one.
Absolutely.
And I think that was also what was reflected in all my fellow jurors too. There was caution, there was care. They considered it, very deliberately. So we spent about a day and a half deliberating, and what happened. So over time, I thought he was guilty, but I just needed to see everything fall into place. I was able to connect those dots through deliberations, mostly on that Thursday night, and then we came back to continue deliberating on Friday morning, and it became very, very clear. Everything lined up, and I'm like, oh, yeah, I'm convinced beyond any reasonable doubt. Two other people became convinced beyond a reasonable doubt, just based on the roundtable discussion. And we went through everything, and it was open discussion. By the way, there's no formula, there's no outline, no legal anything for how you deliberate a case. It's 12 people by themselves. They take our phones. We can't have any outside contact with anything. And we have to sort it out. And the foreperson is supposed to kind of be the referee and kind of guide, keep things from getting out of control or off the rails, whatnot, which is not a problem that we ever had. But we're trying to wrestle through some of these things and know that it's not a perfect case. So there was, what we had to figure out is what is reasonable doubt. We know we can't be 100% certain that this defendant shot this victim, right? There's no absolute unassailable proof, but we're required to assess whether it was proven beyond a reasonable doubt. And what is that definition, right? That's I think where it got really hard. So overall, we were in trial for a day and a half, and we deliberated for a day and a half. And it
Okay.
it was taxing on the basically on Friday morning when we all came back, and we were, nobody slept well, man. Everyone felt the weight of this. Nobody was, what's the best way to say it? Nobody was just shaking this off and saying, "Oh yeah, this guy's guilty," and just let's get this over with. We
Yeah.
were we were all seriously considering and reconsidering all our positions. We all got like no sleep that night. Came back, everyone's looking rough, and we're talking about, how was your night or whatnot? How was your kids? And just no one, just, man, we just, it's tough. So, and I know I'm not explaining that well. I have a hard time translating that
It
aura,
was
you
it
know.
was probably fucking it was probably hell. I mean, let's be honest. You got the guy's freedom in the palm of your hands. You've got all the evidence, and you have to make a decision. And so that whole process can be grueling. And
Yep.
like you said, eight right off the jump from the moment you start. Eight said he's guilty. Three of yous were kind of like, and then you had the one person who was just like, no, they didn't prove the case, and I don't believe him to be guilty. So, I mean, I guess that had to play a part in it too.
Yeah. So how it turned out was eventually those three people, including myself, I just needed to get things sorted out and solidified and be sure I was making the right decision. Right. I
Yeah,
just
no,
needed
I know you said it earlier. I'm just saying that
and then
it was,
yeah, and I'm not talking about anything you talked about. I was just kind of reflecting on my thoughts and then giving you a timeline. Two more came around and said for sure he's guilty, and then there was one holdout, and it just wasn't enough for her. I think she wanted a perfect case, and it wasn't a
mm,
perfect case. It was you just got to get to reasonable doubt, and for her, we didn't reach reasonable doubt. And quite frankly, that's fine. I was not upset with her. Whatever. I believe everyone did exactly as the law required and as their conscience required, without bias and taking it seriously. So that Friday morning, obviously the biggest part of this was the defendant or the victim's testimony. It hinged on just two things: the victim's testimony and the fact that that gun was found on that guy. And it did not help that it was 2 months later. If it was like 5 minutes later, open and shut,
yeah.
right? That would have been easy. But man, 2 months, that's a little bit different. We asked the judge, so we can send notes to the judge and ask him questions and this, that, the other. Um, we found out halfway that we should like consolidate those questions because apparently they have to reconvene everyone in the courtroom and
Oh,
read the
okay.
question out loud and all that just for transparency. So we were firing off, we were peppering off questions, all that. And then the deputy that was assigned to us, like, well, if you could maybe if you got a few more, let's get them all in. Okay, fair.
Gotcha.
I learned something. I didn't know how that worked. And the
Okay.
foreperson didn't know how that worked either. So we asked a few questions of the judge during our deliberations. We touched on every aspect of the case. We rehearsed the whole thing. Each person went back in their notes, which are all different, obviously. Sometimes I wasn't taking notes because I'm like, no, I get this part. I understand it. I don't need help remembering it. Other times I was just like, no, this was critical. I need to write it down. So everyone wrote down things at different times and we would compare. And one thing we did on Friday morning was to request a transcript of the victim's testimony in its entirety. So the judge gave it to us, and then 80 pages the foreperson read out loud, and it
Wow.
probably took an hour or two to go through that. And we would stop and say, "Oh wait, what did he say right before that?" Okay, just getting into the nitty gritty of what he said because it was so critical. That was such a critical part of the case, but in the end, we were deadlocked. That person, we tried to convince her she would not change her mind. So we sent a note to the judge that we didn't identify her. We didn't say we're 11-1. You don't say any of that. We just said we cannot agree unanimously after extensive efforts to do so. We don't see any path forward. We don't see any way that this would change.
Wow.
Please advise. So the judge brings us into the courtroom and he gives us, and Bill's Mafia will appreciate this. The judge gives us what's called an Allen charge. And
Oh, okay.
an
Wow.
Allen charge it's not Josh Allen in front of like Deion Dawkins just gaining yards because of the charge. It's telling, okay, you're really close. You need to now double down and you need to talk harder. If you have a position that if and it literally says if your position is not shared by the overwhelming majority of your fellow jurors, you need to at least reconsider it. You don't have to change
Wow.
you don't have to change your mind. You should not change what you agree what you should I forget the verbiage, but you should not change what you absolutely believe in, but you should consider all the points that are being made by your fellow jurors. And then he sent us back to do that and deliberate more. And it went nowhere. We knew that we were at an impasse and there wasn't much to talk. And we hardly really talked when we got back. We just said, well, what can we do? We got to go through the motions now and review some parts of the case. But we went through everything. I mean, we had a day and a half of the case and we had a day and a half of deliberation. We hit on every point.
And she was not budging, this
She was
particular juror.
she was not budging. And it was basically, it was not that he was not guilty, but that she felt that it was not enough to prove
And
beyond a reasonable doubt.
what did she elaborate more on why she felt like that?
Yeah, that's a good. There were some things that came up. She did say, and I hate to go down this road because it doesn't matter, but she was obviously not familiar with constitutional law.
Okay.
She said one thing, and I don't know that this necessarily made the difference. And she could be watching right now. I don't know, but she just said, "Well, I only heard one side of the story. Defendant really didn't defend themselves." And we said, "They don't have to. That's your constitutional right to not say a word from the time that the police talk to you up until the point that you're in court on trial for it. It's your absolute right to not say, anything. So we can't take that into consideration, right?"
No, but maybe maybe he's a sly fox, Mark. Maybe he said, you know what? If I do all this dumb, silly shit, maybe I get just one person.
Yeah.
I get just that one person who's like, this is just, and it's just enough to convince that one person that I either didn't do it or, there's not enough for them to have proven that I did it. You know what I mean? Because
Yeah. So let me say this. I was sympathetic to that person's position. That was the
Okay.
position of probably four of us when we first got in the jury room, in that there's not absolute proof. It's a reasonable doubt, not a zero doubt.
Gotcha.
And where do you, how do you just make sure? So I got it. I'm not mad at her. And like, I didn't agree with her, but it wasn't enough for her. And
Okay.
she said, I just want one more piece. We've got these two pieces of truly circumstantial evidence is what they are.
Okay.
No one actually saw the gun get fired. At least that showed it. Now, after the case, I can tell you that I'm almost certain that there was a lot of people around. Almost certainly somebody saw
something. They just
something,
weren't
but they're not going to talk
snitching.
about
Yeah,
it.
they're not exactly.
They're
Yeah.
not going to snitch. Not going to show up at the trial. There was
Gotcha.
they subpoenaed one witness for the trial. It was the dad that was cooking in the back barbecue. He wasn't even close. He was just around the corner and heard stuff.
Oh, okay.
He did not want to be there. He would barely answer anything. He was just angry looking, would not answer questions. And I could tell that they forced him to be there against his will. They subpoenaed him as a witness, which you can do.
Was he the victim's dad or the defendant's dad?
He had no, I don't think he had any relation to either one of them.
Oh, okay. Because I thought you said the dad was in the backyard cooking or something.
No, well, I'm sorry. Yeah, that's not a good way to put it. The dad of someone, like the man of the house,
whoever was having the party,
whoever was hosting the party, whoever owned the house, that sort of thing.
Gotcha. Okay.
And he was like the older guy amongst all these younger men that were there. So, all right, he's the father figure, let's say, of the situation. So,
got you. Okay.
He was out there barbecuing. They brought him up to testify. That didn't last long. He didn't want to be there. He would hardly answer. It was just interesting, and I could tell that it was like even if he knows something, he doesn't.
He ain't saying nothing. I didn't hear nothing. I ain't saying nothing. Gotcha. Yep. Exactly.
So, but to go back to the deliberation, all we had was circumstantial evidence, and that is a fact. And it was 2 months between the gun was fired and the gun was found on a guy. No one saw that gun shot, or at least no one came forward or was
and said they saw him shoot that gun. Gotcha.
Yeah. So what do you got to go off of? That's tough, and that's why I think it took so long in deliberation. The state did a good job presenting. They did their best with all that circumstantial evidence. They tied it all together as much as possible, but that I would say made it extremely difficult on everybody, because there is that little bit of doubt in the back of your mind.
Yeah.
What if we're wrong?
Mm-hmm.
What if we're not thinking about this right? All of us, even.
Yeah.
Just can we live with ourselves, or not that it matters for us. It's like, can we go ahead and vote guilty on this in light of the fact that we don't have perfect proof
Got you.
that he shot. And so I think that was the weight on all of our shoulders. I think that that's probably a weight that happens a lot in Chicago or any city where there's a lot of gun violence and where you have, shootings. And shootings happen for a lot of reasons. And I don't know whether this, I don't know why, I don't know if this had any gang relation. I don't know if there was any beef beforehand. I don't know this guy's history, this defendant, no history whatsoever. I looked up his history afterwards.
Oh,
And
okay.
he's a felon who's shot at people a lot of times. He's got convicted a lot of times, and he's
Okay.
a gangbanger and all this kind of stuff. You don't know
But
that.
at that time, you don't know any
Yeah.
of that.
And as well, you shouldn't, because you shouldn't. You're just looking
Biased,
at
no bias. Yep.
this case right here.
Yeah.
So I thought that was really well handled. And another part was during the jury instructions, the judge's instructions were very good, very strong. Like, you are not to talk to anyone about this case. You can't even talk to your fellow jurors outside of the jury. So let's say another person on the jury decided the same thing as me, like, oh yeah, I want to get a hotel, just hang out. And I said, all right, let's go out for a steak. Let's have a drink. Let's do this. We're both jurors, but we're not allowed to talk about that case over dinner because we're not in deliberation with the other 10. And you can't look up anything about the case. You can't do any research. The judge told us, do not drive to this location, in the southwest area of Chicago. Like, literally, he's telling us, don't do this, don't do this, don't do that. You've got to. And it's a bit of a, you got to trust your fellow jurors, and the judge has to trust us, not to do that. It wasn't a case where we were sequestered necessarily. In a bigger, high profile case, they can sequester you, and they can basically, you're almost a prisoner of the court for a few days. They tell you what hotel to go to. You're escorted by a deputy everywhere you go, all that stuff. It wasn't that crazy. So there's a little bit of a trust element in there, but the instructions were very, very, strict. And obviously, if you are found to have violated that after the fact in any way, there are consequences for that. And so, that was another weight of responsibility on us, I think, that we were thinking about. And I know everybody took that seriously. To kind of wrap it up and to kind of close out what happened here. So we got the Allen charge, which didn't involve Deion Dawkins, unfortunately. And we went back and we said, we've tried, Judge. Your Honor, we've done everything we can. We've talked about everything. There's nothing more to talk about. We're 11-1. We've asked everybody, would you ever consider changing your mind under any circumstances? And the answer was no. And so at that point, we sent that note out. We don't go back out unless they call us back out there. And the judge walks into the jury chambers and said, well, ladies and gentlemen, thank you for your service. I've declared a mistrial because you could not reach a unanimous conclusion. You are free to go. I'll give you your phones back. I'm going to give you the certificate for your service. And that's it. So what that means is if we don't reach a conclusion, then the state is free to try the case again. I don't know whether they'll try the case again. I would be curious, but Cook County online court records are like non-existent. So I can't even look it up to see out of curiosity. I'd have to go down there. So they'll probably try again. The judge, after it's all over, then it's just open discussion. The judge is like, so where were you guys? And we're like, well, we're 11-1. And they're like, which way? 11 guilty, 1 not guilty. He's like, oh, okay, interesting. And the judge is like, well, you know what? This didn't come out in the trial and everything, but I can tell you that this guy is a multiple gun felon who's been arrested for this type of exact thing and convicted on the same thing before. Didn't come out at trial because he never took the stand, but just for interest's sake or whatever. And we're like, well, yeah, that's interesting, I guess. And we said, what's going to happen? He said, this whole thing is going to probably happen over again. The state's probably going to try it again because they think that they can probably get it the second time. And he'll probably defend himself. He probably can't be convinced otherwise. And so we'll see this whole crazy little bit of a circus again. And I don't know if that will happen or not. Obviously, I'm not even looking into it, and it's too difficult to look into it. But it was just really interesting. But to close out my story, and then maybe get into some questions or talk
Yeah,
about
we got 13 people who have tuned in for the whole experience. So if they would
yeah,
like
that's
to ask some questions, Mark will be, Mark is free to, answer them. And so we look forward to any interaction. But I've got some here myself. But go ahead and finish up, and then we'll get into some of it because some of this is very interesting that I want to get into. So go
yeah.
ahead.
And so and again, please, if you're listening tonight and if you have questions, I would love to answer your questions. And there's no such thing as too small, or there's no stupid question, anything like that. Don't hesitate. Let me know, because I think this is an important topic to discuss. And I think I just had such a unique experience. Whatever I can share. Um, here's what it did for me. First of all, it was an experience like none other. It was a weight, emotionally, psychologically, like none other. I came home that Friday night, and I didn't turn on any music or anything. I just drove silently back to my house in the suburbs for like an hour, just thinking about things, because it's so much to process. And I got back, and my neighbor happened to be out at the time, and his wife and kid were away, so he wasn't doing anything. I was like, man, I got a crazy case to tell you about. You want to have a drink? So he came up, and we had a little drink, and we just talked about it. But he said that I looked, this doesn't mean anything, but he said I looked more exhausted and broken than he'd ever like seen me before. Like, just your face, man. And it was
Yeah.
interesting that some of that stress, I probably had some early wrinkles or something because of it. But it was such an impactful thing, that it affected me very strongly. And on that, I would say, listen, folks, don't try to listen if you can't make it, or if you got a good reason, if your employer isn't paying you, whatever. Fair enough. But if you can serve as a juror and you don't have a good excuse, you need to go in and do it, because it's very important to our democracy. It's very important to our system of justice. It's very important to maintaining what I believe is the fairest and most just system that we have in the world. And I believe that was demonstrated. Um, another thing that gave me confidence. So this experience gave me a renewed sense of confidence in the criminal justice system. All 12 of us strangers from different backgrounds, from different ethnicities, different ages, different family structures, whatever it may be, all over the place. We all came together and we did this job. And everyone was singularly focused on being fair, on being fair to the defendant, on being fair to the victim, because the victim deserves justice. The defendant deserves justice too, and if he did it, he needs to be locked away. If he didn't do it, then he needs to be free, regardless of what the evidence says, right?
Yes.
So that was, I think, probably comes into another part of the weighty fact that we're trying to seek justice for this young man who had his life changed forever. He doesn't have use of his legs. He's going to be in a wheelchair and dependent on other people for the rest of his life. So
Absolutely.
you're trying to get justice for him too. But everybody was very, very serious. Nobody, I think, exhibited any biases or even said anything slightly. Everyone said that we must do our jobs according to the law, according to the Constitution, and they put their time into it. They offloaded other things. I'm sure we all checked emails, when we could at night, kept up with work. But when we were in that jury room, everyone was concentrated on doing the right thing. And our entire discussion was focused on doing the right thing and making sure that we had turned over every possible rock, that we were not missing anything, and that if we were going to return a verdict, whether it was guilty or not guilty, that we were returning the right verdict. And I just think that is the best system of justice that you can imagine. I just got to see it live. I got to see it in front of my very eyes and be a part of it. It's no small thing. It's a heavy responsibility. But with 12 strangers, we did our jobs. I'll conclude the story with this. At the end of that time, I thought justice had been served and had not been served. Justice had not been served for that victim who had been shot. I was convinced beyond a reasonable doubt of the defendant's guilt.
Okay.
Him getting to wait for another trial or whatever may happen, the state might not even try. Him not being convicted of attempted murder and aggravated battery when in fact he did that, and I am convinced of it, justice was not served. However, justice was served in relation to the law, in relation to the Constitution, in that everyone must get a fair trial by a jury of their peers. All 12 must agree unanimously. The state must prove beyond a reasonable doubt and convince every single one of us
Yeah.
of that guilt. And that didn't happen. And in that sense, justice, I would say from a constitutional perspective, justice was served. And that's like just the big like thought bubble that I came out of that experience with, is that
And
I didn't agree with everyone, but that is the way that we in America would rather let 100 guilty people go free than convict one innocent one. And I know it doesn't work
absolutely.
every time. I know there have been innocent people convicted. There has been bad science, and I hope we've gotten better over the years, and we have. There's still problems. It's
Absolutely, because the guilty man went free until they decide if they're going to retry him or not. I mean, like you said, they might just say, you know what, screw it, we're just not going to retry it. The money, it's going to cost too much. I mean, they're 90% going to retry it. I'm sure
yeah,
they
I'd
are,
be
but
shocked. I'd be shocked if they didn't. So
but if it was someone else, a little high profile, a little higher up into the stratosphere, we see it happen. OJ Simpson, we don't got to get into it, but, we see times where the justice system doesn't work properly and whatever have you, loopholes people can use or what, but it seems
well,
like
and that's
you're,
that's the thing. It
go
just
ahead.
takes even I don't not even I couldn't tell you the details of the OJ Simpson case, but I remember probably watching it as a kid. Like it takes a lot to convict someone, and we're going to let a lot of guilty people go free to avoid convicting one innocent person. And
Yeah.
some I realize that some innocent people have been convicted, and
Yes,
thankfully
absolutely.
there's been some exonerations. Thankfully, the science has been updated. Thankfully, the liars on the stand have been exposed later, and that's a tragedy. It's terrible. Um, but I think overall, this is the best possible system. I
Absolutely.
don't see any way that you could do it better and still do it fair. So that's what I walked away with, and it was just it was just a unique experience, not your average trial, man. And so, Jay, I appreciate you letting me come up and talk about it a little bit.
No,
Uh,
I thought it was a great thing to talk about. I mean, the whole justice system is upside down right now with everything that's going on. And like I said, we don't have to get into it and make this a political episode. This was just, I wanted to talk about this particular case, your particular experience, from your viewpoint,
right.
because I'll be honest with you. They send me them shits, and I don't even. I throw that shit in the garbage. I don't, So if they ever decide they want to come and arrest me for not fucking going down there, then oh well. But yeah, I don't bother with that stuff. You know
Well,
what I'm saying?
okay,
So
that's a unique perspective because it depends on the courts and the judges.
yeah,
But
oh yeah, they could come
we'll
get me
have
if they want to. Yeah. Oh no, I get it, and maybe I shouldn't do that. Maybe I should, you know, you know,
you definitely shouldn't do that. You're
Yeah,
lucky.
absolutely. I'll probably have to rethink that process. Maybe if it ever
Well,
happens again, I better go down there, huh? Anyway,
probably should just to
yeah.
cover your butt, right?
Yeah, exactly. Because no one wants me on their jury. I could tell you that much. I'll be biased on
Well,
everything.
and that's the thing. Like if
That's
you
got to be tough.
go in, you got to do according to the law, and you got to go in, you got to answer the summons. But yeah, you're not likely to get placed on a jury.
Yeah, yeah, definitely not. I mean, I just wouldn't be. It just wouldn't be smart at all.
Yep.
Um, But yeah, I got some questions for you. I wrote a few things
Yeah,
down.
no,
You know,
fire away, man.
so here we go. I got one. So describe your understanding of the principles of beyond a reasonable doubt and how you would apply it in the context of the attempted murder case.
Yeah, that was something we had to wrestle with. Um, there's no definition given for beyond reasonable doubt. There's no legal definition. There's nothing in the judge's instructions. We know it's not beyond any doubt because
Okay.
there could be doubt to anything. Even a 99.999% case, there's still that lightning strike possibility that something wasn't, as presented. Um, and I think that reasonable doubt was probably the thing that we wrestled with most in the deliberation room. Um, because you don't have to be 100% assured of guilt. You just have to be so assured that it's just virtually impossible, not impossible, but virtually impossible for there to be any other conclusion. So, what does that mean in terms of numbers? Is that a 95% confidence rating? Is it 99? Is it 99.9? That's what we wrestled with in the deliberation, and it means different things to different people. In the end, I think it meant something different to the one juror who could not issue a guilty verdict. I think that it was such a strict standard for her that they had to not just prove it beyond a reasonable doubt, but absolutely prove it beyond any doubt whatsoever.
Mm.
But that is something we all wrestled and struggled with the whole time, and we talked about it at length throughout the deliberation. So that's a good question. I think that's probably one of the toughest questions that we all dealt with.
And so did she say what that one thing was that was it just the fact that it was 2 months that had gone by since they had caught him before they had caught him with that particular gun? Was that the one thing that she just couldn't get past? That there's nothing's to say that within that 2 month period he might have bought that gun off of somebody or
Right.
found it or whatever have you.
Mhm.
Was it that one thing? Do you think it was, or did
I,
she
I
not
don't think
share that with you?
I don't think it's that. No, and she did share. It's not that one thing. It was the fact that the 2 months found the gun is kind of like, that's not perfect evidence. Then the other big piece of evidence that we had to consider is the victim's testimony. And this victim was confident that this guy shot him, and he looked him in the eye and said, "You shot me. You shot me." Um, there were no eyewitnesses that came forward. So with her thing, and she did tell us, she was like, one, it's the lack of eyewitnesses. It's the fact that the gun find is stale by 2 months.
Okay.
And we don't have anything else, third, to corroborate that. It just wasn't enough for her. That's what she said. And we said, well, for us, everything else is enough. And there's a lot of things I didn't mention that kind of there's dots and all that we got tied together. And that's what I had to do was tie it all together. But for her, it wasn't enough. And that's where she was hung up. So no, I don't think it was one piece of evidence that failed. I think it was the collective failure of all the evidence
The
to
entire
convince her.
case.
Yep.
And the only reason why the victim knew that it was the person who that the defendant was the person who shot him was because not only did he pat him down in the alley, he saw that he had the gun, and then you said he pulled up in the red Pontiac, right?
Yeah.
Um,
And so
you
that's
said
another
there was
piece.
something distinctive about that you were
Yeah,
going to tell us about.
no,
You
thank you.
forgot
So,
about that,
so
yeah.
yeah, that's another piece of circumstantial evidence. When the police arrested the defendant, they arrested him out of the driver's side of the red Pontiac.
Okay, gotcha. So that's
So,
what that was about. All right.
so all that means all that does is go to victim or go to witness testimony. It enhances the credibility of the witness testimony. which is a
Yeah.
big thing for me. For me, the whole case rested on credibility of the witness, and I had to figure out whether this guy was credible or not. I found him to be very credible because internally I tried to poke holes in every aspect of his story, and I couldn't poke a hole. It all lined up perfectly. He wasn't lying. If he could have said in court that he saw the defendant shoot him. He could have told us that he had not yet turned around and he saw with his own eyes. Nobody could have refuted that unless some other people came forward and wanted to speak to this split second turn of events. But he did it, and I talked about that to the jurors. There was one moment where I kind of did what I'm doing now. I kind of gave this 20-minute impassioned, probably wasn't that long, maybe 5-10 minutes, this impassioned speech of my conclusions as to witness credibility. I'm like, this guy had every opportunity to boost his case. He had every opportunity to say, no, I definitely did see him, and to make sure and just sock this away for the jury. And he didn't. He still admitted that he did not see him. And his testimony was consistent throughout. It was consistent with everything that the state's attorney presented. There were no holes to be poked. And so that was one thing that, and I know I'm like taking a tangent from your question and everything.
No, you're
You
fine.
brought up an important point there, and that we had to, that, the red Pontiac was a part of that evidence.
Yeah.
Same dude, same car, has a
Same
gun.
gun.
Gun
Yep.
was tied back to the shooting. The only thing you don't know is what happened, in those 2 months, and you don't have someone that had their eyes on that trigger pull.
Absolutely. Okay, and that's good. And so here's the thing: you basically kind of answered my second question. I'm gonna read it off just so you
Yeah,
know
no,
what
no,
it
go ahead.
was.
We'll
But
talk
you,
more about it too.
you kind of you answered it in what we just spoke about. And the second question was, how would you approach evaluating the credibility of the witness's testimony as evidence presented during the trial? And you basically just said that when saying he told us that he didn't see the guy shoot him, you know what I mean? But he's saying you shot me, you know what I mean?
Yeah, and you know what? I would say one more thing, Jay, on that. It's interesting that the law, the judge, they don't give us any guidelines in regard to evaluation of witness credibility. Well, that's all on us. We're just instructed to evaluate the evidence and the testimony, and we have to decide for our individual selves how credible it was.
Well, let me ask you this. In a normal trial, there would have been a defense attorney. And because I don't know much about lawyering or, jury trials.
Sure.
Um, is that defense attorney then allowed to try to poke holes in the credibility of the witness? I'm sure they should be allowed to, right? Within reason.
Absolutely, and that's actually one of the main things that they do. The
And
main
so,
the, hey, listen, if the state has a pretty good case, if the state has identified the guy, the state's witness identifies the guy, if they find the gun, if they prove the gun is back there, that's about all the defense attorney can do is poke holes.
yeah, absolutely.
And add those elements of doubt, add reasonable doubt. He could say, for example, but like, hey, what wasn't said was that on the he could, for example, say, well, there's a Chicago police report out there. This is just theoretical. I'm making it up. This didn't happen. Yeah. But he could pull some reports and say, well, this gun was also found on this other individual, a few weeks earlier. So the fact that my client just happened to have it at the time of his arrest, doesn't mean my defendant's the one that pulled the trigger. This gun was getting passed around. It was getting sold or whatever. So that's just kind of a made up way that he could poke holes. But yes, you have an opportunity. So there's if the state is presenting its case, the state calls its witness and the state asks all the questions that they're going to ask. Then the defense has the opportunity to cross-examine that witness and to try to one word that came up, and the defendant actually used this. He must have read some legal stuff somewhere. He said he was trying to impeach their testimony. That's a legal word. That's a legal word. That means basically prove that their testimony is not credible, or that they're lying, or that they don't know everything they think they know about the situation. So a defense attorney would poke holes in that, and
Yeah.
he would ask questions to say, but didn't this happen as well? Or he would say, and I can't. It's hard to give theoretical examples, but
No, I get it. It's just all those things didn't happen in this case because this was a very
correct,
strange case because
correct,
the defendant chose to represent himself. So you didn't see this thing play out in the courtroom in a traditional manner
not at
because
all.
it wasn't a traditional case. And that's what I find so, interesting about it is that still into this day that you have the right to defend yourself whether you're capable of doing it or not. They will
Mhm.
still let you do it, and it's the
Yep.
dumbest shit in the world. You know what I mean? And unless you're educated and you know what the hell you're doing, then it could be whatever it is. But I was always under the impression that when someone chose to defend themselves, they at least have to have a attorney present at the table to kind of help them with the case because they don't know what the hell they're doing. But I guess if you say you don't want the public defender because that would be the lawyer who would be sitting there with you helping you out throughout the
Mhm.
case, but because he didn't want even a public defender, he was just out there doing whatever the hell it was that he was doing, and I mean, hell, it worked.
And, I guess it worked in this instance. Yeah, you could say that it worked. But yeah, the U.S. Constitution, it says you have the right, just as you have the right to remain silent and not say a single word to the police, you also have the right to remain silent and do absolutely nothing at your trial. It is the government's burden to prove it. You don't
Yes.
have to do a thing. Now you can. Most people
Yeah.
do. I'd say it's advisable. I think I would get a good defense attorney and try to poke holes. If it were me,
Yeah.
but you don't have to, and that's a very strong and enshrined constitutional right. No judge or anyone can force you to have an attorney.
The defendants almost never they're almost never witnesses in their own trials because once you get on that stand, the prosecution can bring anything that you've ever done to light. You know what I mean? You are
Yep.
totally, and so most people who, are guilty per se and, just have to let the process play itself out. Most people know that. And so they don't present any kind of, you know, testimony themselves because they know
Right.
that can be that can happen to them. So
And
like
there,
you said, yeah, you
yeah,
have the right to just sit there, shut the fuck up, let the professionals take care of business, and whatever happens, happens. But
yep.
you didn't have that in this case. You had, an ill-advised person, and I mean, yeah, like I said, it worked, but in the sense that I'm sure if they do decide to retry him, he will still be locked up while the trial is going on, right? Because he had sheriffs all around him, so he must have been in custody.
No, he was definitely in custody, and so that's
Yeah,
that's another thing. Like he was in custody pending trial, and
yeah.
Illinois, and we don't have to segue into this, but uh, excuse me, Illinois recently became a no bail state. In other words, there's no Illinois outlaw bail. You either get
Wow.
you either get locked up pending trial or you get released.
Okay.
And so it's really drawn a hard line between some of these, some of these big cases and how big is the crime. And yeah, there's then people are all over on the political spectrum, and I won't even weigh in on my opinion. I think that's another show, but
Yeah.
it's but if the crime is serious and there's enough, if there's enough evidence to take it to trial, and if it's like something like this, attempted murder, and depending on the record of the person, if they've been caught with guns before, this, that, and the other, then the judge is going to lock them up pending trial. There's not going to
Yeah.
be any bail. Um, but in most cases, unless it's really serious, they're gonna let them go, and they're gonna say, well, you need to
Hope that
show,
they come to
up for trial.
court. Yeah, yeah,
Yep.
yeah. Got you.
So yeah, he was absolutely, in custody. That I can look up. So I did look up days later. I did look up on the Cook County inmate locator, which I've used before for different things in my neighborhood and such. That's another another pod. But
Are you a
um,
neighborhood watch guy?
yeah, well, it gets deeper into
HOA
that.
or whatever they call
I,
it. Don't
I'm
are
I'm
you a
a
part?
I'm a HOA president. Not
Got
for
you.
much longer. I'm going to get out of that at the end of May. But we've had some issues, some criminal elements. I've just been curious if like they lock someone up for something or if they let him go. But anyway, so you can look up like whether he's in custody or not. I did look up, so he's
Okay.
definitely still in custody. So
Well,
they'll
that's
they'll
fine.
probably they'll try him again.
Yeah,
I'm
they're
almost
definitely
certain they'll
gonna
try
try
him
him
again,
again.
and they'll probably get the conviction. I don't think they'll end up with like the one. You're unlikely to end up with that one person who just cannot be convinced. That's what I would guess would happen.
Well, you may have answered this third question as well because we've talked a lot about the whole thing, but I'll give it to you anyway. My terrible is or my memory is horrible. But it says, can you provide an example of a situation where your personal biases or opinions might influence your judgment as a juror, and how you would strive to remain impartial? Like, was any of that going on during the whole process?
That's that's a very good question.
Okay.
Um, and here's why we touched on it a little bit already. Um, Everybody has implicit biases. That is a fact. If you think you don't, you're wrong. Everybody has something internally where they, as soon as they see a certain person, type of person or situation or whatever, there are some sort of conclusions that are going to be drawn. There's some sort of context that they're going to apply to it. um, I was scared to death of my implicit biases. Not, I don't, I'm not, I don't have any. I believe I treated this defendant would treat any defendant fairly, but like, I think in the back of your mind, it's always that devil on your shoulder
Hmm.
that you're like, am I missing something? Is there something inside of me that's causing me to arrive at the wrong conclusion? That's what you struggle with, and it goes back to just the weight of the decision, because you do have implicit biases. One thing I would mention is that, to his credit, the judge did address implicit biases, and he straight up said in the jury instructions that we all have implicit biases. We need to recognize that. We need to take that into account. We need to be on guard and be cautious to do our best. We can't prevent it completely, but to do our best to make sure that those biases aren't creeping up, and we need to try to recognize those implicit biases when they're there. It's very hard because, again, they're implicit, not explicit. So I think that, um, I think it's just an internal reflection, and
Okay.
you can never be 100% certain of yourself, if that makes sense.
Yeah, see, I could never be a juror or a jurist, so however you say it, because I just, yeah, I wouldn't be able to do, I wouldn't be able to do that. Like, I
Yep.
wouldn't be able to just look at the evidence, and you know what I'm saying. It's like, you know, I don't know, man. It's strange. That's a whole strange type of
Yeah.
process. I
But
mean,
it's important. That's what it takes, man. That's what it takes to run a fair republic. If you'll forgive me, Jay, I need like a quick bathroom break. If you can,
take
if
your
you
time.
can
We'll
take the
we'll we'll
time.
do a quick break
So,
and we'll come back.
um,
I gotta
yeah,
go
we'll
to.
jump right back
Yep.
into it here.
Okay. Yep. We'll take a quick
And
5.
hopefully there's some questions up that we can get answers to.
Go ahead, take your time.
All right, thanks.
All right. What's up, folks? Anybody got any questions they want to ask Mark about this experience that would have probably drove me mad? I don't want to be involved in none of that type of stuff. Although I know it's the American way. I don't want anybody's freedom in the palm of my hands. I don't want to have to be in that type of situation. Um, no, I just don't need that type of stress in my life. Well, it says 16 people are watching, but I don't have no questions yet. Usually I got people in here, all kinds of questions. No questions for Mark tonight, huh? So give me a little snack. I like my dry roasted peanuts. I gotta try to stay away from the peanut M&Ms. Yeah, I wouldn't be able to go live by myself, stream by myself, unless there were people to be in the stream talking with me. Hey, what's up, Mark? I was just
Hey,
talking
what's up,
to
Jay?
her to.
Thanks for giving me a little break there, man.
No,
You know,
take
I
your
know
time.
you're all by yourself, which is kind of sucks.
Nah, I was pretty much talking to myself. I was, letting any one of the 16 viewers that are watching, if they wanted to ask you any questions about this experience, to feel free to jump into the
Mhm.
comment section and, ask your questions. And, Mark will, and myself will answer whatever we can. But I'll move on. Did we already get to the third one? Right? That was the last one I asked you, right?
Yeah,
With the
I know you had a
Yeah,
few.
with the
We talked about
biases and
these
opinions, yeah.
beforehand. Um,
Yeah, nah, I just like I was reflecting while you were away on the whole thing, and I just, man, I guess if I were told I had to do it, I could do it, and I would hope that I could be impartial and not let any of the outside, things, biases like that get involved. But I don't know, man. I really don't know, and I guess you don't know until you're in that situation. You know what I mean? You may
yeah,
have thought the same way, like, man. How could I sit and judge someone and not take, anything that I feel about certain things into consideration and just judge the person totally on the evidence that's presented? That's a hard fucking,
yeah.
thing to be asked to do. You know what I'm saying?
It's incredibly hard, and I had no idea how hard it was until I was put into that situation. And Jay, you're right. Nobody wants to be in that situation. Listen, I was always willing to serve. It's a civic duty. You get called, you get called. And I thought there's no way I'll ever get called because I've got cop friends and all this other stuff. But then here we are in the craziest case where none of that matters, and they actually want you on the case. It just, but I think we all have to be willing to serve.
Well, here, let me just clear
If we're
something up.
able.
Hold on. I just want to interrupt you for 1 minute. I don't mean to
Go
be
ahead.
rude, but let me
Absolutely.
just clear one thing up. It's not that I don't um go down there when I get the notification. It's not because I'm not patriotic or I don't care about my country and I don't want to,
No, no, no,
be serviceable.
absolutely.
It's just because I've got a criminal background. I got a
Mhm.
criminal history. I've got, in my younger days, I was you know,
A little
I was
wild.
a young kid,
Yep.
and I got myself into some trouble early on in my late teens, early 20s, and so I would never be able to sit on a jury anyway, so it's just there's no point in really going down there, you know what I'm saying? So that's why I don't
But,
go down there. It,
but that's not for you to judge, Jay. I mean, if you got the summons, you're qualified to serve.
oh, okay. I didn't know
So,
that. I thought if you're
and all that other stuff gets sorted out. And you know what? By the way, they ask you, and it's a little bit personal, man, and something I didn't talk about, but I will now because you brought it up. I think it's good. Uh, the judges' basic questions. We didn't get to like the prosecutor and defense asking you their questions because there was only one side. They didn't care. There was no one to contest. Whoever the state wanted on the jury.
but
The judge's questions on his standard questions to you, they get personal. So another question that I was asked was, they do ask you, I think, I don't know if they asked you about criminal history. I don't know if that came up actually. So I don't know. There's different jurisdictions and stuff, but they do ask you if you or a family member or a close friend has ever been a victim of a crime. That can get really personal.
For sure.
And
And that should disqualify you. If the answer to that is yes,
no,
then
well,
that
not
should
necessarily.
automatic.
No,
No,
not
you don't
necessarily.
think?
It all depends. There's a million different crimes. I don't know. I didn't have the opportunity to see someone. I had to answer yes to that question. I have a friend that's been a victim of a somewhat serious crime. So
Okay.
not only am I the cop buddy, but then I answer yes to that question. And again, you think you'd definitely be off the jury by then.
Yeah,
But it does.
if there was a regular attorney there for the defense, you would probably have been excused.
Right,
Yeah.
when that question gets asked, it's not like, oh, a yes answer disqualifies you. Like, what kind of crime was it? Does it relate to this case? Is it the type of crime that tends to, based on the knowledge that we have scientifically, give someone a bias or send them down a road that or down a path they can never come back. So it's not just a yes or no. It's not that simple. Um, but yet again, I had to answer yes, and you would think all of that put together would result in me not getting on a jury. But hey, I don't know that necessarily having a record would exclude you. Now there are certain convictions of certain crimes. I don't even know what they are. It does make you ineligible to vote or ineligible, and maybe it would make you ineligible to serve on a jury. But that happens that day in that courtroom. It's not decided beforehand. If you got the summons, then
Oh, okay.
you know
So it doesn't get decided until you're actually down there sitting in the box, and the judge and the
right,
prosecutor and
right,
defense are asking you all these questions and shit. Then I would say, well, that they probably asked me something like that, and I would have to
sure.
say, because I mean, I'm sure if you've been, I'm well, it is what it is. Yeah. So I guess next time when I get one of those, I'll go down there and check it out,
It's
see what
it's
it's all
definitely
about.
better to go down there because if you ignore it, they can technically just arrest you for it, and that's not a good
Okay.
situation.
Well, then
I
I
don't know
better
if
not
I
do
don't know
that
if they
anymore.
would. I don't know how. Like it depends on the sheriff of your county. I don't know how hard they would enforce that. I don't even know how well they would enforce it in Cook County. Probably not. I
Well,
probably
I've done it a few times, and they've never come. It's not like they come knocking on my
yeah.
door, taking me
So
downtown. But
I don't take it that seriously.
I guess next time I'll do it. What do you got there? Oh, you got a nice drink there. What are you drinking tonight? Anything special? I know you got
Got
a
a little.
beautiful, beautiful rack.
So tonight's. Oh wow. Well, thank you.
Well, no, I meant I was gonna say pause too, but then I thought, man, I'm 48. I'm not saying that. But anyway,
Uh,
you usually have your liquor bar behind you, so you
Yeah, I
must have
usually I
switched it
usually
up
got
tonight.
the bourbon collection. I'm sitting
Yeah,
on the other side of just the other corner of the room tonight. I didn't want that to be like a distraction or anything.
yeah, that's fine.
So that's all. But yeah, I've got one of my favorites that I'm enjoying tonight.
All right,
Um,
well, let's get to these last two questions, and then we can go ahead and just get into, like, getting into the nut and bolts of how we see the whole justice system in today's in the country today.
yeah, and if
You
any
know,
of you out there just want to fire off like a comment or a question, or even if you want to say something super controversial or whatever on the topic, let's go. Let's have an open discussion. That's what I think we wanted to do. It's a hot topic today. You've got the Supreme Court issue. You've got all these other things going on. You've got people
yeah,
that
man.
aren't in that system that feel like they can't trust it. And what I was bringing to you guys tonight in the story isn't necessarily to change your minds about anything or to say that some other court is or is not doing the right thing or the Supreme Court, but I think at a baseline at the grassroots level, what I've seen is that our criminal courts, at least here in Cook County, which is big, they're doing the right thing. It's handled right. We are following the Constitution. You do have a fair shake. if you're taken to trial. And that's all I wanted to, I guess, bring up tonight. But I'm, absolutely open to any questions, thoughts, or comments. I know that it's a hot button issue, and I think that's why, Jay. I think that's why you wanted to talk about it tonight, because this is very
Yeah.
important for society. It's worth getting into. It's worth having a discussion on, amongst many other issues. And so I just appreciate you, kind of turning your show to off of football for like a night, just so we could hash this out.
No, I like I said, I'm definitely, and the more that I've heard about this whole experience that you've gone through, the more I'm angry with myself now for not going down and at least presenting myself for the option to be able to do my civic duty if they pick me or not. I mean, the more I'm hearing about it, and how I am very passionate about what's been going on in the country and things that bother me, then sometimes you have to also do your part when you're called upon to do it. And so that's what
Absolutely.
I'm getting. That's the most that I'm getting out of your experience, is like, damn, maybe I could have been someone to have, um, you know, save someone for being found guilty on something that he didn't do, or vice versa.
Great.
Maybe I
Yeah.
was the person who helped, put someone away who hurt someone or whatever have you. But the fourth question is in the case of the conflicting evidence or interpretation of the law presented during the trial, how would you work with your fellow jurors to reach a fair and just verdict? So basically, like, what was it that you took from all the evidence that you were able to, explain to the other jurors who made, like, that one juror? What were the things that you were trying to have her look at to change her mind? Or, I know you guys said that you really didn't try to change her mind, but that you guys had to at least try to convince her
Yeah,
that
well,
maybe,
we
you
did.
know,
I mean, we were all so a couple things on that. First of all, it's all about respect in the first place, and we were all putting ourselves in her position once it became 11-1. We don't want to gang up on somebody and,
absolutely.
and just harass them, or we don't want to what's the word, crowd think, if crowd think is the word. We don't want to just overwhelm one person because the other 11 think a different way. That's not fair. And that's not our justice system. That's not a court. Again, she has the absolute right. If she truly feels this way, then she ought not to change her opinion regardless of what she said. However, she should, on the Allen charge, she should absolutely consider it. Give it another shot, give it another thought, like have more discussions. So we were trying to convince her, because at the end, but politely, and it did get a little tense at times. It absolutely did. It didn't get disrespectful, but it got tense. And I think that we all, several jurors actually expressed their hesitancy to say anything in that moment, because they did feel like they were ganging up on her, and we felt like it was going to be this big mosh pit. And but we tried to convince her, and one of the there were several pieces that we tried to use to convince her. I focused on witness credibility, the credibility of the victim witness, that after having read it over, after having heard it for the first time, taken notes, thought it over, slept on it, looked at it again, and then we read the entire 80-page transcript, it became there was no, any holes that were there were from my lack of memory, and it just filled it in. And I just said, this victim is absolutely credible, and they're not lying, and they don't have anything to gain. We talked about, and this is a tangent, but we talked about the possibility that this victim, even though they were shot and paralyzed for life, we talked about the possibility that they were protecting somebody else by pinning it on this defendant. And so I said, how? What does this victim have to gain? What can they possibly like? If they wanted to sink this ship, if they wanted to sink this case, the best thing they could do is not show up. Then we'd be stuck with no evidence. Almost, you'd be stuck with the 2-month-old gun evidence.
Yeah,
but they showed up. And I guess, and that can get confusing because I guess, if you're trying to pin it on someone else, then you would show up to testify against this defendant. I get it. But I guess what I'm saying is they didn't have to do anything. They didn't have to, testify, period. And the Chicago Police Department, the detectives, they were asked, I believe, whether or not they had, I think actually the defendant brought this up, and it was one of his questions that was good. It was a good cross exam, and the judge didn't strike it down. It was a right question to ask. It was a fair question to ask. He asked, were there any other suspects that you were looking at, or was it just me? So, and they said, no, there was nobody else. There were no leads. Like you were the only one that was identified as being at that party, that was identified as having a gun, that we found the gun on you later and all that. So the only other possibility, the only way that victim could be lying is if he's trying to protect somebody. And there was just no possibility of protecting someone else. There just wasn't that part to the case, unless I'm really missing a true lightning strike, 1 in a million possibility. So that's where I think to go back to your question, Jay, and I realize I kind of rambled, but I'm having fun with it. I'm enjoying it.
No, it's fine, man. Like I said, I don't hear. I mean, I've gotten a few texts, and so I'm gonna read 2 of these texts.
Good.
One is
let me just finalize the thought as to your question.
Okay.
So we basically, when we tried to convince the one holdout, we tried to convince her based on witness testimony of the victim. That was basically what we fell back on, and we said this is just so strong and so immutable. That's a big word, I know, but that was what we fell back on. So.
All right. So listen to this. So this is the critique of me tonight in this particular interview. All right. One text, and I want to ask if you feel like this has happened to you tonight in the show, and I want you to be honest, okay?
Sure.
And if anyone that is viewing believes this to be true as well, please comment in the section and let me know, because this is something that I guess I'll have to learn not to do. But we have a coach is obviously watching the show, and he said,
Coach,
you need to learn how to let people talk, guy. People said you needed to talk more. They didn't say you needed to make a comment on every statement. That was from Coach. Now, my sister,
hang on. One at a time. Let me address that.
Okay.
Coach, all right. So Coach is right, and he's wrong, and he's not wrong for being wrong.
Okay.
You did jump in here and there. Okay. But listen, this shouldn't be a monologue by me. All right. So what I thought, Coach, when Jay jumped in here and there, he's just giving me a break. Maybe I need a break. Maybe I need someone to just stop and give me a breather. That's what I read. So I mean, maybe there's some times where it's not a perfect time to jump in, but I appreciate, listen, I'm going to say Jay did the right thing here. I think Jay was trying to give me a chance if I needed to breathe, because I was deep into a long story, and I need to take breaks. I mean, I had to stop, take a bathroom break. I got to get more water here in a minute. So, man, I get it. Yeah, and we can always refine the way we do and Jay's very open to refining the way he does the pod. But Coach, I don't mind at all. We're here to have a discussion, not a monologue. and I've been talking most of the time, and so I would like to hear even more from others. So
And
that's okay.
so as much as I hate to admit this, my sister also, my own flesh and blood, agrees with Coach. She said you're talking too much and you're interrupting him too much, and that was what was said. Those were the two text
She
messages.
he's
So
good. He's good. Everybody, don't worry about it. This is what it's all about. And he's the host. He has the right. He can interrupt me whenever he wants. It's his gig. He could kick me out of here.
no, I don't want to be Stephen A. Smith. I want to be I don't want to be that guy.
No, but it's all good. And listen, here's the other thing. Some of those times Jay interjected, he did actually bring out some points that I had either forgotten to mention or maybe got out of order in my. I had a whole plan and everything, and the best laid plans, that they're hard to follow. So it really is fine. So and I appreciated some of those pauses and some of those stops to just to follow up and just make sure. It's like he had clarifying questions, which is good. Coach or Jay was like, "Hey, wait a second, doesn't this work this way?" And I was like, "Oh yeah, that's a good important point. Let's hit that up for a little bit." So it's all good.
Hey, I thought I was doing a good job. Maybe I do. But I'll tell you this, Mark. If you knew me personally, see, like my sister knows me personally, and so I do that. I tend to do that. I tend to kind of like interject, interrupt, and because I want to get my point out. So I mean, I guess I can kind of see where they were coming from,
Yeah,
but I
you're
guess I'll
you're
go
you're
back
just a
and watch and
talker.
see.
You're just a talker.
Yeah, I'm a motor mouth, bro.
Yeah.
I just
Hey, the best part is being able to admit that, right?
Hey man, and try to do better. I guess I'll watch
Sure,
more. I
sure.
guess I'll watch more interview based shit when I'm gonna do something like this for the future. But I'll give you this the last question, and then we can just get into whatever. And whenever you're ready to be done, we can shut it down. You know what
Yeah,
I'm
I'm
saying?
I'm hanging out. So let's get honestly. I would love for another question to trickle in. Seriously, there's no dumb questions. Say something controversial. Just make me talk. Whatever. This is what I signed up for tonight. And but I do want to just uh, I guess reiterate the what I learned from this case.
So the last question is what steps did you take to ensure that you fully understood the instructions provided by the judge and applied them appropriately throughout the trial proceedings?
Yeah, I think I took, and other jurors probably did the same. I think that we took notes. So when the judge, there are parts of that trial, particularly at the beginning where you're getting instructions. There's two parts to that. At the beginning, you get instructions because you've never done this before. You've never been on a jury, or at least we presume you haven't been on a jury, and you've got to follow certain things. We got to deal with implicit biases. We got to make sure you're only looking at the evidence. Do not do any research. Do not talk to anyone. Those are all instructions that you get at the front end, like before the trial begins. And then there are instructions that are given to you as you, excuse me, right before you get the case. And those are basically the deliberation instructions is not the right word. There's some word out there and someone can fill it in. But you get instructions on how you are to assess the testimony you've heard. And it's basically a reiteration of some of those initial instructions, as well as here's what your job is now to do. And it's very, very focused. So I think that those things were very clear in our minds, because it's kind of like your dad standing over you with the stick, like you will or else. And I realize that like sounds like the judge is beating us up. It's not that. It's like we're again, the weight of the situation is reflected in our approach. And so you realize, you feel the weight. You want to do everything right. You want to do it according to law. You want to give everyone a fair shake. You want to carry out justice for the defendant as well as the victim. And so I think that, we all listened closely to the judge's instructions. I think that we fell back on many things in deliberation. Some things came up in deliberation, and we were all like, no, you can't consider that. You can't. That's not fair. You can't. That's not evidence. That came up a million times. Just we were all checking each other, and we were all just listening to each other, like, oh yeah, that's right. Like, we missed that, but we got that, or you took notes on that, and we all. When something was a matter of law and a matter of procedure rather than a matter of evidence, we all paid attention enough to agree on it, and then we all checked each other if anyone got out of line, respectfully, without humiliation, without ganging up or anything like that. That stuff happened.
Okay. Now, let me ask you this, if you wouldn't mind being able to tell me what were the different demographic, like how many women were there versus men? How many were, of a different
absolutely. Ethnicity.
You know what I'm yeah. I'm not even going to try to say that word. I'll fuck it all up.
I'm trying to remember what the gender split was. I don't remember it. It was split for sure. It was kind of even. We had it was majority white as far as ethnicity.
Okay.
We had people and we didn't ask. No one asked what anyone's background was. It's more like just looking at them and the characteristics and stuff.
But you know what I'm saying.
So obviously we had a few people, men and women, from a Latino background.
Okay.
The white men were basically middle-aged white men, like myself, like within 10 years. And then the one holdout doesn't mean anything, but I think the one holdout, the female, I think she was the only African American on the jury. Again, I'm just assuming based on, because there's a lot of skin tones and stuff like that.
No, I get you. I mean, it wasn't meant. The question wasn't meant to put you on the spot or anything.
No,
I just thought
for sure. But no, I thought that would come up. I honestly anticipated that coming up because race is a big deal right now.
Absolutely.
And there's a lot of tension in that regard. And so I would say it was just it was pretty much a mixed bag.
Okay.
But I think the most important thing is not like our backgrounds that we came from. It was just the fact that we were able to all get together as a group and just have that discussion, have that very stressful deliberation, and still work together cleanly and smoothly, even though it was rough at times, even though we disagreed. Everybody listened to everybody. And that, I think, was the most important part. But yeah, it was definitely a mix of backgrounds, a mix of ethnicities, a mix of ages, younger, older, for sure. Yeah, it's probably the best I could answer that. I think that's a fair question. I actually expected that to come up tonight. It's good.
Would you say you were the youngest guy out of the group of older white gentlemen that were on the jury? Would you say you were the youngest man out of all the men? Because you said it was mainly older white gentlemen, right? The male,
like middle age, which I don't even know what that means. But no, there were men that were older and younger than me.
Okay, got you. No, I was just trying to see like the demographic. Yeah. Was it more senior citizen? You know what I mean? Like, you know, or do they just try to find, is there a certain type of person they want, or do they get, because like you said, the defendant, there was no one there to object to any of the jurors, correct? Because you said he was defending himself and he wasn't even there for the jury.
He skipped out. He could have declined people himself, and he just decided to just stay back in the lockup.
Absolutely.
But it was definitely a mixed bag. There were no, I would say, senior citizens. I don't know if this has anything to do with it, but In Cook County, senior citizens, if you're above a certain age, you're allowed to opt out. You can just,
Oh,
yeah, you can mark your thing and you can send it back in and say, hey, I'm 70 plus years old. I would just rather not, because it's a lot if you live in the suburbs to go down to Cook County, park in the garage across the street, deal with the traffic, try to get there, go through the crowd at the courthouse. I mean, that's it's like going to O'Hare Airport. It's exactly like going through security at O'Hare,
mm.
and the parking is the same. So they let senior citizens opt out. I don't know if that had anything to do with it. I don't know if most folks, of retirement age and above opt out, or if that just happens to be where we landed on this case. But yeah, it was all over the place.
And so the group of people that you went in with, you said it was 40, I believe, or 20. You said it.
Yeah, initially. So what they did is, so what happens, presumably down in the courtroom, is the judge says, okay, we're ready to proceed to trial. Now we have to select a jury. So they send a note up to the jury room, and they say we need two groups, or we need 40. There just happen to be 20 people per group, the random number assignments.
Okay.
So they start out with 40 people from which to pick 12.
And
And
this is. Oh, I'm sorry. Go ahead.
no, that makes sense, because normally the attorneys would be picking people off. They'd be like, not him, not her, not that. We're gonna
Yeah.
eventually kind of it's probably like the draft room for the
Got you.
Buffalo Bills here in a few weeks. So like, okay, they're not available, they're not good. Who do we want there? So they give a wide pool, a broad pool, and then they can select 12 jurors and several alternates. By the way, I didn't mention this, but there were 14 people as jurors watching that case. Only 12 decided.
Oh,
Um,
okay.
that's in case someone gets sick or have to leave or whatever. They can continue the case. So if I got like hospitalized with some infection or something and I couldn't serve, well, we've got two alternates, so somebody would still be on that jury. And by the way, you don't know whether you're a juror or you're an alternate the whole time. You can't,
Oh,
because if
wow.
because if you're an alternate, then you're gonna be biased. You're gonna pay less attention. Be like, well, I'm gonna get dismissed anyway. I don't have to follow this. You have no idea. And so at the end, when we get the case, they say, okay, juror number 7, juror number 12, you are alternates. Thank you for your service. You're dismissed. The remaining 12 will go in to deliberate it, and you
Oh,
don't
wow.
you don't even know whether you're on the staying here list or you're on the you know excused at the end list. And that's another aspect of it, I guess. That's interesting.
No, that is crazy, man. Wow. That's insane. Um, yeah, man. I think the whole thing is fascinating, man, because at the end of the day, bro, this is how it's done. You know what I'm saying?
Mm-hmm.
And if people are beginning to not trust any of law enforcement, from the FBI, it's all kinds of conspiracy shit out there now. And so for you to go through the process and see how it works and see that it really does work and that it's, set up in a way that it's supposed to work and it works that way. I don't know. I just think it was a fascinating experience. I kind of fucking wish now I would have been on some trial like that. You know what I mean? I mean, I'm sure you guys bonded in a way. When it was all
Yeah.
said and done, did you all go out and have a drink together or anything?
Nah. We left and went our separate ways and probably drove home in silence like I did.
That's crazy. And you said your friend thought he said you look like it fucking took everything out of you, huh?
Yeah, my neighbor said I look like a train wreck. So
Now, was
it,
that
it was
because oh, my bad.
good. No, go ahead.
No, I was just gonna say, is that because the guy, you knew that a guilty guy might have walked away from a situation where he actually did do the shit, and you got to hope that they retry him because there's nothing says that they're gonna retry him, you know, but that they most likely will.
It
But there's
wasn't.
that possibility.
It wasn't that. It was the whole thing. It was the weight. It was the weight of two things. It was the weight of having to decide such a significant criminal case and a significant outcome on this defendant's life, and we you have to get it right. You can't convict him unless he's truly guilty. The worst thing that can happen is that you convict him and you're wrong and you miss something. That weighed heavily. So that's one thing, and the other thing is just the deliberations and the craziness of the case. Like what you got so many wild cards thrown at you. It's not normal, like at all. You're not supposed to consider, right, whether the defendant is represented by attorneys or whether he's not. None of that has anything to do whatsoever with what the evidence and the things that you're supposed to consider. Yet you've watched it. Yet you've seen it all. Yet you've seen someone that is floundering in some ways. So you got to figure out whether you got to feel bad for him or not. There's just all those things. And then the deliberations were very difficult because not everyone was on the same page. And so we're all trying to, I think like the majority is maybe trying to convince the minority, but yet we just don't know. We can't, we don't know 100% that we're right because it's circumstantial evidence. So it was just the fate of another individual in your hands, and having to go through all that, stick with the evidence, stick with the things that you were, to stay within your lanes, right? To not go outside the guardrails. And that was very, very difficult. But you're cognizant of all of that. It doesn't, yes, you don't consider anything outside of those things. You can't. But you know it, but you see it all, but you subconsciously consider it. And that weighs hard. You're trying to block certain things out and make the right decision. So it's just an exercise that's very difficult to go through. And I think that's what it does. And it was, I can't explain everything. I can't explain why it was so difficult, but I was a mess on that.
Yeah, man, that shit's tough, bro. Because it's like, how do you not allow your biases to cloud your judgment and get involved? Like, it was like, was there any point that one person who said, "Nope, you can't change me"? Was it any point where maybe somebody was like, "Well, man, I kind of feel the same way she feels, but this right here makes me, be
Absolutely, yeah,
you know."
yeah. Yeah, there was sympathy there, and there were points at which I thought we could convince her. At the end of the day, I don't, I just think that she looked at it with a different lens than the rest of us. That's the only thing I can identify, just because we all came to the same conclusion except for her, and we all got there in different ways, and we all got there with different timing. And couple of these people, it took like most of the deliberations for them. And I didn't know if they were gonna, I didn't necessarily expect, on Friday morning to walk in there and see two on the fence votes change to guilty. But that's what we saw. And that was a big part of of sleeping on it, just going overnight, having that personal time just to reflect. And I'm rambling now. I'm not really
No,
saying
I didn't know that. Wait a minute. You just brought a whole new fucking layer to the case, or maybe I zoned off at some point in the interview, which, whatever, it's probably going to happen from time to time. But you're telling me, oh yeah, you're right. I remember it now that you guys were it was 4, 1, and 2 at the night that you guys said you're going to go sleep on it. And then when you came back the next day, you said it became.
Yeah, no, it was actually, so when we got the case, when we first went into deliberation after everything had rested, it was 8, 3, and 1.
Yeah, that's what it was.
So,
8-3-1.
and I was leaning guilty. The others said they were kind of leaning guilty. So I became convinced throughout that first night. I put the pieces together, and then the other two out of the three, I had my decision, and then the other two kind of came into their guilty verdict overnight and into early Friday. So it was 11-1 early the next day. Most
Man,
most most of the chatting happened on Thursday, and then people slept on it. People just had a chance to kind of be quiet and reflect, and then we got back together, and then 11-1 was pretty strong, and then that didn't change, and there's no hope of changing it. We turned over every rock that we could. I'm still surprised. I don't know. I don't know what the one was thinking, and that's fine. That's our justice system. As I said, justice was served constitutionally because that one person held out. That's her absolute right. And if that's the way she feels, if that's how she believes, then she ought not change her belief. It's
yeah,
fair.
but that may have worked in this particular case, but could you imagine, it doesn't seem it might not work like that in all cases. Like some, if this was another case, those people may have just grinded her down until she just said, all right, you know what, fuck it, not guilty, just because she
Yeah,
wants to go home
that's
or whatever, you know what I
That's
mean?
that's possible, but if you think here and that, I thought about that, Jay. Like, okay, so you got it's 12 random strangers, random people. And if you're doing a random selection like that, do you really think that 12 randos on another day is going to act completely different from what we acted? I don't think so. And that's a part of where I was just like, hey, we all had respect. And there was a little bit of grinding. Her position wasn't easy to hold. It wasn't easy to withstand. We did try to convince her. I don't think that necessarily being jerks about it would have changed anything. So I don't know what could have changed. But I really think that we had 12 random people that didn't know each other, that were truly randomly selected, although in this case not as random as might happen if you get a defense attorney involved. But there was the civility and the understanding and the wisdom that I saw in that, I think would be reflected in any random group. I don't think that we got the lucky group of 12 and that you've got the unlucky here, and then everyone piles on against someone. So
Got you. Hmm. And there was just nothing you could say, huh? She said, nope, this is it, and that's that. She did. I mean, that's gotta be tough, man.
yeah, it was, but
There was no messiness. It was like
no,
everybody was cordial, no name call.
yeah,
It wasn't no. Well, I
no,
mean, yeah, it was only a couple of days. Could you imagine if it would have went on for, if they would have just kept making you go back there and it turned into like,
yeah, it could have gone bad. That could have raised the cortisone levels and things like that. That could have made a difference. But that's there was nothing else we could do. We would have sat there in silence because we'd already gone over every piece of the case. Um,
that's crazy.
but yeah, it was completely curious. Completely, it was everyone was great. I'm not mad at anyone in that room, and I don't love anyone in that room either. It's just it was everyone was fair and everyone followed their conscience, and I saw that demonstrated and I saw that explained by every juror.
That's cool, man. That's a dope experience, man. And I'm sure it's something that you wouldn't mind doing again. You probably wouldn't look forward to doing it, but if you were called on to do your civic duty again, you'd be willing to do it again, right?
Now that I've done it once, it would be a lot easier the second time because I know what to expect. But
Got
again,
you.
again, that was a lightning strike. I'll never get called. I'll never be a
Yeah.
juror. That was truly the most improbable thing ever to happen.
Now, do you think that should be changed? The person's ability to say, you know what? Because in a sense, aren't they kind of just wasting the court's time? Like,
What do you mean?
with the whole I'm going to represent myself shit. I get
That's a,
that you
that's a constitutional right.
I
Period.
get that, but shouldn't there be a way where a person is forced to at least have, like, I know most in
No.
cases like that, most people have a lawyer sitting at the table. He may have been able to convince you all to fucking find him not guilty. You know what I mean?
Uh, you as a defendant, you have all the rights. You can do nothing. You should have the right to do nothing. I think that's a critical Fifth Amendment right, and so I would not change it at all. Are some people going to make bad decisions? Sure, but that's a critical constitutional right there.
And I get that, but reasonable doubt seems very flimsy to me, man. Like reasonable doubt is like, like you said, there's no real
It's
definition of it. You know what I
it's
mean?
it's yeah, well, it is individual, and that's why you have 12 people in that room, and you have to come to a conclusion. So everybody, all 12 people have to agree that he's guilty beyond a reasonable doubt. That's a huge hurdle to overcome, and that's why I think it works so well. And yeah, we juries, our jury, probably every jury struggles with reasonable doubt and that definition, and that is tough. But I don't know what else I could say to that. It's
Reasonable doubt is a bitch. That's what I'll say about it,
sure.
because
All right.
it's been the reason. It's been the reason for many of people to walk who have been guilty, and many of people may have not. You know, who have been convicted who may have not been guilty. You know what I'm saying? It's the way one perceives reasonable doubt. I believe that the reason why she stood so firm on her ground is because of the time with the gun. Like I think that's what she would.
It probably was.
I
Yeah.
think that's the thing that was where she sat on her hill. That was the hill that she was on, and she wasn't going to move off that hill.
Sure. But
You know,
and that's fair. That again goes back to we'd rather let 100 innocent men go free than or 100
yes,
guilty men go free than convict one innocent one.
yeah.
Reasonable doubt doesn't convict innocent people. Reasonable doubt protects every defendant. It makes you more likely to get found not guilty, even if you are. That's what reasonable doubt does.
No, no, no. I get that, but sometimes good lawyers, man, they can turn reasonable doubt into a weapon. You know what I'm
Sure.
saying?
Sure, but you got lawyers on both sides of it. So yeah, if you're the prosecuting attorney and you're going up against like the state's best defense attorney, well, then you better be on your game, because then it does come down to
Yeah,
who can argue it better. And
but
there's something to be said for the you know the power of attorneys and what the way that words can get twisted and everything. But I would say I would be confident in our system, in that there's a judge who oversees all of that and doesn't let one side get out of control. And again, it doesn't happen perfectly in every situation, but
no, it doesn't. I
but
mean,
the judge is in control of the courtroom, but he doesn't decide the outcome. It doesn't even come close to it. I don't care what you say. I don't care. People have said like judges influence stuff. Kyle Rittenhouse case was a good one for that. I don't want to go down that rabbit hole, but I'm sorry. Just because someone's loud and just because someone controls their courtroom, you're not affecting the outcome. It's those arguments, it's those witnesses, it's the evidence that the jury is focused on. And that we saw that in our case, because our judge was mad at the guy. He was constantly reprimanding. He was angry at him. He didn't hold him in contempt. He threatened to like 50 times because the guy was not, he would not follow instructions. But he gave him a leash, and we understood that was just a unique situation. The judge has to I guess maintain order in the courtroom, and it didn't affect anything.
Yeah, that's just like I said. At the end of the day, man, it's a very strange situation to not only be on a jury where you wouldn't normally be on it because of your ties with friends who are in law enforcement, and just to be involved in a case where the defendant is representing himself. You know what I mean? It's just a whole things may have been differently had it not been so chaotic like that. You might not even have had to experience the experience. You know what I'm
Right.
saying?
Dude, I'm really grateful to have had the experience. It was educational for me. It was sharpening for me. I mean, it's a story I can tell. It's something I can consider. When I'm talking about with people like this, like this, when I'm talking about the justice system. And so I'm just grateful to have served, and it was a good experience in the end, although a difficult one and a unique one.
Yeah, I mean, it's definitely unique because the things that we see with what's going on right now in some of the court cases that we've been watching with the former president Donald Trump, it doesn't seem like you know the wheels of justice are turning quite fast. But we won't get
They
into
never
all of
they
that.
never turn fast, but they keep turning.
Yeah, they do, but it seems like when it's someone like him, bro, they go really, really fucking slow, dude. And it's
That's
like all the tricks are pulled out, and it's
what
like normal people can't do that shit. I mean, your
good.
guys' trial was over in what, 2 days? You know what
Good.
I'm
Well,
saying?
yeah, that's an apples to onions comparison. So, like, you can't say like one trial has anything to do with the other. It depends on the volume of evidence and how complex it is. But good lawyers can stretch it out. I mean, and that doesn't mean anything. Who cares if it takes a long time? You want the right result, right? However long it takes. Um,
Yeah.
but yeah, good. There's the law is complex, and good lawyers can take full advantage of that complexity, and they can stretch things out, and they can delay, and they can poke holes, and that's just the system that we have. But that system is necessary. The system where everybody has a chance to see every little possibility to its logical end, in order to make their case, is necessary, I think. So that doesn't bother me, quite so much if things take forever, or if
You're not
loopholes and stuff are, I just, and that comes from probably just my opinions or understanding of the legal system.
you're not concerned with Judge Cannon
Who's that?
down in Florida?
Don't even know who it is.
Oh, okay. That's the judge that's overseeing the Jack Smith case against Donald Trump.
Yeah, I haven't followed. Again,
No.
the system's going to do what it's going to do.
Yeah,
So,
I just don't like how it is, how it works really fast for us regular folk. And then, it
but
takes,
the speed is dependent on how complex the case is,
I
on how
get
much
that.
evidence you have. There wasn't a lot in this case. A day and a half was actually long for the amount of evidence that went in my case. Doesn't have anything to do with Donald Trump's case and just the
Oh,
level
no,
of.
I know that.
So it's not. I don't think it's common man versus rich man. Although there is common man versus rich man, there are factors. There, the attorneys, as I said, can drag things out, can bring things up, can. Good attorneys make good. They develop good cases, for sure. But it's, you can't solely look at the amount of time it takes and say that's not fair.
No, I didn't mean it in that sense. I
Okay,
just
all
meant
right.
like, things happen differently when, like you said, you have, said lawyers and and you can drag shit out and prolong it and make it work to your benefit when most of us don't have that option. You know what I'm saying? It's
Well,
like
yeah,
it
yeah. I mean, if you have
things
money, you can buy good lawyers, for sure.
Yeah, I guess that's what it comes down to, right? The haves and the have-nots, brother.
But if you're if you're someone in a position of power or riches, you're getting in different troubles than me and you are. So it's
Yeah, I
just
know, man.
has to play out.
But it's so fucking, aggravating that the rest of us have to actually live by the laws, and and if we don't, we get we get our shit right away. You know what I mean? There's no taking it fucking, letting it drag out forever. It ain't, because you're related to, the current president, you can fucking have your shit, taken care of behind closed doors and get sweet deals and all this bullshit. It's like, bro, it just ain't, you know.
Well, I think you're painting with a little bit of a broad brush because Trump. Let's talk about Trump.
Well, no, I'm talking about Biden as well. I mean, like his son's
But let's
getting,
talk about Trump in particular because Biden. I'm sorry, Biden's not being prosecuted right now. There's nothing to talk about.
absolutely not.
Trump is being prosecuted in addition
That's
to several
true.
cases.
Yes, that's
He
true.
he has attempted to reschedule these things to push them out past the election. This, that, and the other. Those efforts have been denied.
Yeah.
So I would say it's not that there's just like we got to stop painting with a broad brush and saying, oh, this, that, and the other. No, look at what happened with the case. Did he or did he not try to push these cases way out past the election and delay and do this? And did he get denied? Yes, he did, from what I read. And now
Yeah.
there might be a 30-day delay on something to do something. That's nothing. These cases, all right. So I in my job, my corporation has been named as a defendant for, and I won't even get into it. There's no good reason. We're not in trouble or anything. It's just someone left us some money, and then like the insurance company, they're disputing it or whatever, so they filed a lawsuit. The case is dragged on for more than a year over some. It's just a stupid little case. So I would caution against reading the headlines and saying that that's how our court system works, because the headlines, it's all sensational news reporters. They're all bad. They're all just trying to get clicks. It's just terrible. So it's just there's nuance to it. And if we're going to talk about and I'm happy to at another time maybe talk about how fast or how slow the wheels of justice have turned with some of the bigger cases that are on the national stage. But it's not a case of it dragging on forever. And I would say there have been attempts to delay it forever, and those attempts have been struck down. But yeah, things can take a long time.
I just want to watch it, man. I'm 48, so I got to watch the entire O.J. Simpson trial. I got to watch the Mendez, oh man, the brothers, the Menendez brothers. They killed their parents for the money and all that shit. I watched those. I watched all those trials, and so I know that when it comes time, I know some of these will be televised, and I think it'll be for some good TV, because then you get to actually see the justice system works, because like you said, we're all not in the jury room.
I wish they'd televise all of it. Just let it all out there.
I agree.
There's some reasons not to, but I would say just let it. If a station comes in and says, hey, I want to put my camera in the courtroom and broadcast everything, why not?
They should be able to, because the people in this country don't trust the legal system. You have a lot of Trump supporters who believe the FBI is dirty. This is all, they're trying to railroad them. You know what I mean? This is bullshit, fake news. But at the end of the day, like you said, you weren't the group of people who are the ones who found that the case had merit to go to trial. You know what I'm saying? I know that there's always the evidence is presented to a group of people, and then they decide whether or not there's enough case. I don't know what it's called, but they decide whether or not.
So in some cases, that would be a grand jury.
Yes, there you go.
So, but not all cases are brought by grand jury. It just depends. Most federal cases are brought by grand jury. and
Okay.
that's related to a constitutional clause,
Okay.
but not all.
Okay. So
But yeah, that definitely does factor in, and that's to me that's a formality because in a grand jury proceeding, the only party presenting evidence is the prosecution. That's not a
got you.
prosecution and defense. That's not a back and forth. That's only the state saying, "Here's all of our evidence for why we should indict this person. Do you think that that's indictable or not?" Well, of course they're going to get indicted because they're not coming unless they have the evidence.
Well, isn't there some cases where the defendant will show up at the grand jury testimony and testify?
I don't know.
Oh,
I guess
okay.
it's
I'll
I
have to
guess
find somebody.
I guess it's
Uh,
possible, but what I would say is the defense isn't entitled to a seat at that table.
oh, okay. So they can't be there.
They're not entitled to defend themselves in front of a grand jury proceeding.
Oh, okay.
Mm,
Well, I know that. I just do believe though, if they want to, they can be there to testify on their behalf. I have to
Not
look into
not
that.
not not not
No,
necessarily.
not necessarily. Damn, I wish we knew a
No,
lawyer that would be
it's
willing to
it's
come on and talk with us about this shit.
one-sided. So
Yeah,
but that's
that's
fine because that doesn't, so there's two ways that somebody can get uh charged and brought to trial. So at the end, it's always the judge who decides whether that case can be brought to trial or not. But before the judge decides, there's two ways. There's the grand jury, which they bring out, and that's not even a unanimous thing. I think it's just majority or whatever. Uh,
okay.
but there's also simply a complaint, a criminal information. And what that is just your average arrest. If I were to go outside and shoot off a gun right now, most likely a grand jury would never be involved. The
Yeah, yeah, no, I get that.
the police would come, and
Hmm.
then the detectives in my village would probably write a criminal information, a complaint, and they would submit that to the judge. And all it is we know that Mark did this, and here's all the evidence. And at this time, he did this. The judge would look at that, and the judge would say, "Okay, that's enough probable cause to make Mark, go to court for a jury
Okay.
trial. That's enough probable cause to try Mark for the crime of whatever it is."
Illegally shooting off a firearm or whatever
Right.
have you.
Yeah. So, but then again, they could do a grand jury if they wanted to. So if it's a federal crime, it's a little bit different because the feds. I don't know the details of this, but I know in a lot of cases, for a federal crime to be taken to trial, it requires a grand jury, and that's a constitutional thing. And I don't know where the line is drawn where it requires that or if it doesn't require it. But that's an interesting thing to talk about, because
Well,
it's
yeah. Yeah, it's like, people don't if they don't trust the legal system until they're there, then how do you know if you're getting people, how do you know if you're getting people who are doing it the way you did it? Like, how do we know everybody that does it, everyone that sits in the grand jury box, everyone that sits in the jury box, how do we know that they did it with honor and integrity like you did it? You know what I mean?
Yeah. Well, I think it's because yeah, again, it comes down to a multitude of people that are involved. So if I did something that was inappropriate or illegal in that jury, hopefully at least one other person would call me on it, talk to that judge. I mean, it's like we're amongst our peers. There's a pressure system there. So I guess that's the best answer I could give to. And I'm not saying that everything's perfect. I'm not saying that the lightning strike doesn't happen. The lightning strike, does happen every once in a while. But it just the to distrust our court system without knowing what you're talking about, it that it's one thing to distrust it if you know what you're talking about and can pull the records, which all court records are publicly available. Now we might not, we don't record them all on video, but
Yeah.
every word that's said in court is recorded by a court reporter. Anybody can get that information. It might cost you. You might have to jump through some hoops. It might cost you a little money because it's a lot of paper or whatever. Um, these aren't secrets.
So you can
Anybody
get the
can look at them.
transcript. My bad.
No, you're good.
You can get the transcripts from any trial if you wanted to pay for them. You can get
Yeah,
the entire transcripts
yeah, I believe
for.
so.
Wow, that's crazy.
Well, it's
Listen,
all it's
man.
all it's all recorded. It's all so that's where people like, oh, they paint with a broad brush and there's paranoid, like, oh, they're not treating them right. Like, dude, it's all a matter of public record.
Mm.
You just gotta know to look, and the people that really, say, the people that want to make all these accusations, and especially like conspiracy theory type of things, they can't prove it in the end. But there is proof on file, so I won't say anything more about that. We're getting
Yeah,
into
nah, we there's always we'll be having more of these discussions. Like I said, I'll be going, we'll be doing the Monday, Wednesday, Friday, and we'll be strictly sports, and we'll talk about, what's going on in the world
yeah.
of sports. But then on those off days, if there's topics like these that I want to discuss, and that I think people will tune into for, I don't, we didn't get as many people as we had, the other night because things were a little bit more, level headed.
I'm grateful for those that
And,
tuned in. I'm grateful for those
yeah,
that
we had
showed up for a serious conversation tonight. And listen,
absolutely.
I just want to thank each and every one of you. This was big for me. I marketed it through my Twitter, whatnot, and everything. I wanted to share the story just because I thought it
I
was
did it as well.
important. And honestly, like, if there's anything else that anyone that's watching, if there's something that you think we should cover, let us know. Let Jay know. He's open to anything, all kinds of things.
Yeah,
We, we would
absolutely.
we would love to do that. I think this is a lot of fun, and we're just having a discussion on everything, whether it's sports or whether it's something heavier like tonight.
Yeah, I mean, we really soon, November is right around the corner, so things are gonna start to get really serious in this country in reference to the up and coming election,
I'm
and
just when
so
you tell me November, I'm just thinking like the Bills are already four games deep. That's all I can think.
yeah, man, I can't wait, man. I cannot wait for the draft, bro. I am super excited. I'm sure we'll be on, Monday to talk about some free agency news because everything is happening right now. The
Yep.
big news today with Justin Fields to the Pittsburgh Steelers. I mean, the show was great. Mark, listen, man, thanks for coming on. Thanks for talking about your experience. That you went through that, a lot of people probably wouldn't want to talk about. Most people probably, wouldn't want to share this with someone. It's a very personal experience.
Mhm.
It's very demanding, both mentally and physically. You know what I'm saying? I'm sure
Yeah,
you know,
absolutely.
I'm sure you were stressed out. You were, it it sounded like it was a tough situation to be a part of. Again, um if and when I ever receive another notification, my friend, I will go down there and do the same thing because you've changed my mind
All
about
right.
how
There we go. Come on, man. Just
uh,
all you gotta do is show up.
yeah,
Do
yep,
your,
you're
do your
right. All
duty.
you got to do is show up. You can't sit from the bleachers and bitch and moan if you don't got no skin in the game. You dig? So
Absolutely.
it's my duty, and so the next time I get one of those, I'll go down there and we'll see how it happens. I'm gonna go ahead and wrap the show up, but if you want to stick around and kick it after the show, we can chat it up a bit. Um, Listen, thanks guys for tuning in. We had, not the biggest crowd, but we appreciate everyone who came in tonight. I wish, we could
Yeah,
have got
thanks for
some
tuning in. Appreciate
Yeah,
it.
I wish we could have got some answers, or some questions from some of the people that Mark could have answered. But maybe we'll revisit it again. We'll do a part two. People can see the episode
Yeah,
later.
send them in after the fact. That's no problem.
And
Send
like I
them
said, yep. If you
in.
guys want to comment in on the YouTube page or the Twitter page or whatever, and give us some things that you'd like to discuss, maybe come in and join in the discussion. Like I said, you can send them right to me, and we'll look it over, and we'll set some of those things up. You got anything else you want to say to the folks before we shut it down?
No, that's good. Just thanks for having me on. I think it was really fun to do a little bit of a different topic tonight, and I hope everyone just enjoyed. I enjoyed sharing my experience. I'm blessed to be able to share that and just to be able to communicate that to you guys. So yeah, if you've been in a jury before, if you've even been called up for jury duty, you know what I'm talking about. You know a little bit of this. For those that haven't, I would just encourage you to embrace it. If you get caught up and do your duty, and it's a solemn duty, but it's important, and I think it's hugely important for our democracy. So Jay, thanks for just letting me tell my story. I thought it was unique. I thought it was worth sharing. So I'm just having fun with you on this show every once in a while. And so everybody stay blessed. Have a good rest of your weekend. Hopefully there's not too much green beer. That's
Yeah.
the Saints Patty's Day.
Yeah,
So
we didn't even talk about that. You know what? I mean, well, whatever. I guess we could talk
right,
about that offline. Look, we got two more subscribers, two more viewers. I'm telling you, man, we got to maybe start a little later and go a little
yeah,
later, because I think
for
people
sure.
that you get those people that come in, and there's people out there at this time, they can't sleep for whatever reason. They can't sleep, or they got a lot on their mind, and they're stressed out, and sometimes they'll tune in just because it's cool to hear two people talk about whatever. You know what I'm saying?
Sure.
But
It was good.
we'll go ahead and say farewell to all. Thanks for tuning in. Don't forget to subscribe and check us out next time. I'm your host, Uncle Jay. Stay blessed, and go Bills.
Go Bills.